Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is Monday, November 16th. It's 9:02 a.m. We are involved in sort of final considerations of our mission change rulemaking. We've got the 1200 series agenda before us today. We will start with the consent agenda, but before we do that, we will take roll. Ms. Larson.
Yes, Mr. Chair. Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner Mock.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Excellent. Welcome, everybody. Good to see you all again. I know that we were all busy over the weekend reviewing the materials in anticipation of today's 1200 series rulemaking. We will get to party closing statements here in a bit. We do have a consent agenda before us. Are there any questions, comments, thoughts from commissioners on consent agenda? Commissioner Nanjapa.
Thank you, Mr. Chair. In general, I didn't have any objections to what's before us, but I just had a question related to the pooling orders from extraction. I think one of the two in particular, it just struck me that there was quite a large number of non-consenting owners, mineral rights owners. And I was just trying to understand that just creates a difference in the amount of royalties that they receive. But I just wanted to better just get a sense of how that sort of noticing process works, and how what sorts of attempts are made in order to receive a response.
AAG Davenport or Hearings Manager Larson, do one of you want to speak to that briefly?
If it's okay with the hearings manager, I'll take the first run at it and she can supplement with whatever she thinks I missed.
Excellent.
That's fine. Thank you, Mr. Davenport.
Thank you, Mr. Chair. Thank you, Commissioner Nanjapa. There are a number of things kind of in your question. I'm going to start, if it's okay, by just explaining what non-consenting means in the context of pooling. It means that the mineral owner has not signed a lease for development of their mineral interests or has not agreed to participate in the development as a working interest owner. I think it's easier to understand what it means to sign a lease. When a mineral owner signs a lease, they become a royalty owner. They get a royalty. That royalty is usually free of the costs of drilling the well. But when a mineral owner participates as a working interest owner, that means that they're paying costs out of pocket, and they receive their full share of the revenue from that well, less the costs. So in a pooling context, a non-consenting mineral owner means that they haven't done either of those things. They haven't signed a lease or they haven't agreed to participate in the well. The Commission's rules require that an operator offer both of those opportunities to all mineral owners in a drilling and spacing unit that's to be pooled before the Commission enters a pooling order. So that includes an offer to lease and an offer to participate in the well. Our rules have specific information that must be included in that offer to participate. And the Act and our rules allow a mineral owner, if they feel they did not receive what's a fair or reasonable offer to lease, to protest the pooling application and come before the Commission to challenge the operator's pooling application. In a very brief and simple summary, a fair offer to lease is essentially a process of the Commission determining if it's fair by comparing the terms of the offered lease to other leases in the area in cornering and contiguous units. And I think you asked about the royalty amounts. the Oil and Gas Act does set, in the terms of the statute, the royalty that a non-consenting owner will receive for its share of oil and gas resources. That amount is set by statute, I think, and the lease terms, if a mineral owner enters into a lease terms, that's the process of the negotiation between the mineral owner and the operator or whoever is offering that lease. So those lease terms in concept could be higher or lower than what the statute sets for a non-consenting owner.
Thank you, AAG Davenport. And I believe then also the non-consenting parties, they are not in the way that the consenting owners are responsible for some of the costs, and then they receive the full royalties. The non-consenting owners are not responsible then if there's any other issues, damages, whatever that occur as a result of that. Is that correct also?
So the statute sets 3460-116 does specifically provide, and forgive me, I'm trying to get to the exact right place in the statute, that the non-consenting mineral owner is not subject to liability for things like environmental issues and other things like that. There's a complex situation that happens after the well reaches what the industry term for, I think, generally is payout. At that point, then the mineral owner is converted into, the non-consenting mineral owner is essentially converted into a working interest owner. And the issue of costs at that point is raised potentially, but that's a complex situation. It's kind of beyond, I think, if we want to have a much deeper conversation about it, I'd suggest that we do that maybe at some point in the near future, certainly, and I'm happy to speak to any commissioner, obviously offline, one-on-one as well to explain it. But that's a very brief and high-level view of liability.
Sure. Okay. Well, thank you, AAG Davenport. And I guess just the last bit there is so there's attempts made to contact those mineral owners and for them to either participate or not. Is it also true that there are people that just don't respond that then put them into that non-consenting status? Okay.
Yes.
Yeah, I would love to go ahead. Sorry. Yeah.
I'm sorry. Just quickly, the non-consenting category includes mineral owners who specifically rejected the offers to lease or offers to participate, and mineral owners who just didn't respond at all.
Okay, thank you. I think I'm good for now. I would appreciate a deeper dive at some point, but thank you very much. Appreciate that.
Great. Other questions, thoughts, comments on consent agenda? Great. Thank you, Commissioner Nanjapa, for that. Do we have a motion to approve consent agenda?
So moved. Second.
We have a motion and a second. Is there further discussion? Seeing none, all those in favor of the November 16th, 2020 consent agenda signify by saying aye.
Aye. Aye.
Any opposed? Consent agenda is approved. With that, I believe we will turn to party closing statements. And Hearings Manager Larson, I believe I have the most recent late breaking attribution of time for closing statements. And I believe that if I've got it right, the industry group is first with 9 minutes and 2 seconds. Is that right?
That is correct. So we will start bringing those panelists in right now.
Just as a reminder to all of our 119 stakeholders, the case management order attributed to the parties the time associated for their party presentation, and those that chose to secure some of their time for closing were allowed to do so. And so We will not be hearing from all parties because some parties chose to use their time for their presentations, and then they would not have time left over, but others did reserve time. And so that's how we end up with these sort of awkward time allocations of 9 minutes and 2 seconds for industry. So now that I've rambled on, as you've got everybody into the fore here, it looks like Mr. Matthews has unmuted, and I believe that we would look to you to lead us off there.
Thank you very much, Chair Robbins. Before I get started, I would like to say that to the extent we have any remaining time, we would like to allocate it to the PDC Oxy Noble Group, if that's permissible.
I believe that's within the parameters of how we've been playing ball over the course of the last several months. So we will allow Ms. Larson to keep time, and she'll alert Mr. Neslin if any time is reallocated.
Thank you, Chair. I'll start now, if you wish. We have several witnesses who will be presenting remarks in rebuttal. I want to start by saying a few words about the consultation variance process. Now, I know you've heard about this over and over, so I will be brief. Suffice it to say that industry favors a process by which biologists and other experts at CPW make a recommendation regarding whether a particular location, as conditioned by BMP, sufficiently avoids and mitigates adverse impacts on the environment and wildlife. This course of action is much better suited to examining issues up front regarding providing wildlife critical protection than a process by which lawyers fight in administrative litigation as to whether or not an operator can make a good faith effort to comply with COGCC rules. Commissioner Mesner on Friday spoke about residual uncertainty in the waiver process, but industry is more than willing to live with this uncertainty because the waiver process allows the experts, here CPW as well as the director, to make a recommendation before an application is filed by the COGCC. That's critical to the industry. I also want to briefly discuss the Chevron doctrine and the standard of review that you've been hearing a little bit about. Just to clarify, Chevron is about statutory interpretation. It's not a broad tool that grants agencies unfettered deference. Chevron doctrine does not remove the legal requirement under the APA that the Commission regulations must be supported by substantial evidence in the record. And I submit that substantial evidence in the record does not exist regarding the 500-foot NSOs for aquatic species and sports fish waters. Mr. Kuhlman will discuss the BLM agency documents next. But with regard to the studies in footnote 26 in table 1200-2, I don't believe you will find anything approaching substantial evidence supporting these 500-foot NSOs. To the extent these documents make recommendations, these recommendations are all for buffers of substantially shorter distance than 500 feet. Thank you very much. I'll now pass it on to Mr. Kuhlman.
Mr. Chair, can we pause our time? Chelsea Mira has a presentation to show, and she can't share the screen.
Yeah, time is told. Let's get Ms. Mira ability to share.
We're getting that function set up right now.
Okay. Thank you, Mr. Chair. Good morning, Commissioners. My analysis on 14 federal RMPs, including the 7 listed in Table 1200-1, shows that these RMPs do not support a 500-foot buffer for the species in 1202 C1 RNS, except for gold medal waters. Staff is proposing 3 different aquatic layers: cutthroat trout and Q, native fish and sport fish management, with the last including gold medal waters. My analysis focused on native fish and sport fish management in RNS and not on trout. Buffer distances were discussed in testimony, and we need to make sure we are comparing apples to apples. Next slide. Mr. Fisher with Trout Unlimited brought up a half-mile buffer that 3 Montana field offices enacted. His written testimony, along with the SBP, states that these buffers apply to both Montana's version of Colorado's gold medal waters and native trout, with trout not being regulated under R and S. 2 points. First, it's not appropriate to use buffer distances established for specific trout, which is proposed to be regulated under 1202 C1Q as support of a buffer for species in R and S. These offices did not implement these NSO buffers for species in R and S. Second, industry already stated support for Gold Medal waters being treated separately with its own buffer. Gold Medal waters are similar to Montana's Blue Ribbon waters and is a small subset under 1202C1S. Next slide. The Tres Rios office having a quarter-mile buffer was also referenced, but this is the same issue as the Montana offices. This quarter-mile buffer was established for specific cutthroat trout as shown in Mr. Fisher's testimony and by staff. This buffer was not established for the species in R and S. Next slide. Finally, Mr. Fisher referenced to the Little Snake office as establishing a quarter-mile buffer, but it wasn't mentioned that this only applies to perennial waters as referenced by staff and not intermittent or ephemeral. Additionally, BLM is applying this buffer in narrow circumstances, in this case with 223,000 acres of the field office's 3 million total acres being impacted by NSOs, which is 7.3%. This field office has 20 NSOs. Therefore, this one NSO will account for far less than 7.3%. Thank you. I'll turn it over to Kelsey.
Thank you, Kelsey Waselinki. I will make a few brief points in response to party testimony requesting a general riparian setback. First, it is important to acknowledge that neither staff nor CPW have recommended a general riparian setback for the 1200 series rules. A general riparian setback was not noticed for consideration in this rule series, and we do not believe it is appropriate to be considered at this time. The major concern we have with the riparian setback is the fact that there is no accurate mapping of all riparian areas across the state. Staff provided you with their legal and operational rationale for tying all proposed buffers with map layers that will be updated through future rulemaking. Without an accurate map layer for all riparian areas in Colorado, a setback is unworkable. If any general riparian setback is considered, stakeholders need to be involved from the outset. I would also reiterate the substantial regulations that will continue to protect surface waters, such as spill prevention, containment, and groundwater testing. These are shown on the slide from staff's presentation. For these reasons, we urge you to reject the request for a general riparian setback, and I will now turn it over to Lindsay Ryder.
Thank you. Good morning. I would like to provide additional clarification on the proposed consultation and waiver process. We believe that the waiver requests that will be submitted will clearly demonstrate that there are either no impacts to wildlife or that the impacts can easily be minimized or mitigated. First, I would like to emphasize again the importance of having a site-specific evaluation process that occurs prior to any permit being submitted. This consultation process would be overseen by CPW and BLM biologists. The unique and site-specific conditions of each project will dictate what information these wildlife experts need to evaluate in order to make a sound determination on whether a proposed project has adverse impacts on wildlife or not. Next slide, please. For example, several speakers discussed the map data is not 100% accurate. On-the-ground evaluations with CPW are needed to accurately assess if the sensitive habitat exists or not. If, for example, a two-track road was mistaken for a dry drainage, CPW should be able to simply confirm the habitat was marked incorrectly. Additionally, we believe that many of the sportfish layers have been inaccurately mapped in the dry and arid landscapes of Western Colorado. During a consultation process, CPW would evaluate whether the drainages could actually support a population of sportfish. The photos on this slide show intermittent and ephemeral drainages that have recently been designated sportfish management waters. These drainages are completely dry for significant portions of the year, so would obviously not be inhabited by sportfish. We have also discussed the nest surveys, that nest surveys can be conducted to determine if a raptor nest is being utilized or not. CPW and BLM have used seasonal timing restrictions for raptor nests to mitigate impacts to species listed in 1202C. You've also seen examples of existing locations that currently exist within an NSO. A common and preferred minimization method for operators is to reoccupy existing well pads or pipeline corridors to avoid additional disturbances to adjacent land that may fall outside of the NSO buffer. CPW and BLM biologists will agree that this strategy is preferred in nearly every situation. Next slide, please. Finally, with respect to the greater sage-grouse 1 mile lek buffer, I believe that the research completed in the Piceance Basin on the Piceance Parachute Roan or PPR sage-grouse or other Colorado research should be relied upon for this rulemaking rather than the reference material and data collected in other states. On Friday, Fred Jarman, Deputy County Manager for Garfield County, elaborated on the unique and extreme terrain features in the Piceance Basin. Mr. Jarman provided the reasons why flexibility is required when evaluating impacts to the PPR population. We again request that you allow for a waiver or exception process in consultation with the applicable agencies. Thank you.
Does that conclude the presentation? No one wants to speak to the backup slides?
That concludes it, Chair Robbins.
All right. Do any commissioners have questions? Commissioner Messner?
Thank you, Mr. Chair. And I do want to thank the additional information that this group provided as far as dates for updating the RMPs. That was helpful. One of the other RMPs that was cited was a draft RMP from the Eastern Plains Field Office that included 500, I believe, 500-foot riparian setbacks as their preferred alternative in South Park. Mr. Kuhlman, are you familiar with that one? And would you like to comment on that? I saw that it wasn't included in your presentation.
Yep. So yes, it does. So there's 4 alternatives right now, and it is, as you said, in draft. Let me just get to my notes. If you give me about 2 seconds. Okay. Yes, and we included this in COGA's response to the October 9th draft, that the Royal Gorge Field Office does have a draft resource management plan with 4 alternatives. 3 of those do not have NSOs. As you stated, Commissioner, the alternative does suggest a 500-foot NSO to perennial waters in wetlands and a 100-foot NSO to intermittent and ephemeral waters. They haven't taken action on it. That is their preferred method, but they have broken it out to have perennial waters in wetlands in a 500-foot NSO. Again, that's waivable, like all the other BLM offices, and then a 100-foot for intermittent and ephemeral.
Okay, thank you.
You're welcome.
Thank you for that. Any other questions for the panel? All right, thank you, and industry panel, for your presentation. We now will turn to the wildlife hunting and angling groups, as well as the citizens groups, for a 4-minute and 51-second presentation. Everyone bear with as we bring the next group to the fore.
I can begin when you're ready, Mr. Chair.
Are you on your own there, Mr. Randall?
I am, thanks.
Okay, good. Then you have the floor. Thank you.
Super. Good morning. I just want to respond to a couple of points raised in testimony last week. First is industry's assertion that the record contains inadequate support for staff's proposed Rule 1202C. The weight of the evidence in the record supports staff's proposal to protect the highest priority habitat areas, including the statement of basis and purpose, reports cited in that statement of basis, decisions on federal land management plans, CPW's testimony last week, the written testimony of party witnesses, oral testimony the commissioners received last week, and witnesses' answers to the commissioners' questions. As to riparian buffers specifically, industry says that they've had 10 years of experience with 300 feet, but that the record doesn't demonstrate any inadequacy justifying the move to 500 feet. First, the 300-foot buffer reflects the commission's old mission, wherein it was to balance development with protection and take into account cost effectiveness and technical feasibility, whereas Senate Bill 181 imposes a new standard to protect wildlife, first through avoidance. And second, the commission heard uncontroverted expert testimony on the value a 500-foot buffer provides to water quality, aquatic species, and other wildlife species that depend on intact riparian buffers for high priority aquatic habitats. As to big game, several expert witnesses testified in support of a development density threshold of 3% in big game migration corridors, after which further development would require a variance. Importantly, this isn't a blanket NGD requirement for all big game migration corridors. Also, not everything within a corridor is created equal. The science clearly shows that biologically significant areas for big game are crucial to long-term survival. These areas are known in some instances by CPW biologists and will be identified and mapped further over time. The Commission should include in the rules now the scientifically defensible protection for these habitats, with the understanding that the rule will only be applied once the maps exist and are adopted by the Commission. And finally, these two recommendations for moving big game migration corridors and biologically significant areas into 1202C are supported by the lack of any scientific evidence demonstrating that impacts in a migration corridor can effectively be mitigated. Several expert witnesses testified to this fact as well. Thus, there is substantial evidence in the record, and there's ample testimony from the state's own wildlife experts at CPW to which the commissioners can defer for you to adopt Rule 1202C as proposed by staff. You commissioners know this. These topics have been the subject of pages and pages of pleadings and testimony from many witnesses, and industry's blanket statement that the evidence doesn't support the proposed buffers ignores this record. Second, I'll address industry's request that the avoidance provisions of 1202C be subject to a standardless waiver by CPW rather than subject to a variance procedure before the Commission as recommended by staff. Industry has two complaints about requiring this rule to be subject to the same process as exceptions to nearly every other Commission rule, the burden of the variance process and the sequence in permitting. As to the burden, the Small Operator Society complains that variances would require an application for a hearing, involve the presentation of testimony and exhibits, and result in a 510 hearing before the Commission. As a matter of policy, each of the elements that they complain about, formal application, presentation of evidence, and public input, should be required before dispensing with the requirement that the most sensitive habitats be avoided. As to sequencing, industry seems to argue that a waiver by CPW early in the process via a Form 4 sundry notice would provide more certainty than a variance by the Commission. And I won't go into this in detail because I think Commissioner Messner noted in his questioning last week that that is just not the case. Because the application that includes a waiver of 1202C would ultimately be presented at a hearing, the operator would not know until the very end of the permitting process itself whether the commissioners agreed that it would avoid impacts to wildlife. This is arguably later in the process than if the operator simply sought a variance in the first place. So the sequencing argument really falls flat. Industry's request for an unfettered standardless waiver provision in 1202C would not comport with Senate Bill 181's direction to minimize impacts to wildlife by first avoiding impacts. It's also simply a matter of bad public policy. Site-specific waiver on a case-by-case basis would frustrate a holistic view of impacts on these habitats and face the possibility of a death by 1,000 cuts. It also excludes the public, whereas the public can participate in a hearing before the Commission on a variance. It's not transparent. The hearing record is far more robust than a Form 4 that's stuck in the file, and it improperly delegates to CPW the duty to protect wildlife from the impacts of oil and gas operations. That responsibility lies with the Commission under Senate Bill 181, and I urge you to visit with CPW about the burden that would fall on them if they were to do this on a case-by-case basis and see what they think. Finally, industry points to the process BLM undertakes when considering waivers from lease stipulations in support of its argument for a waiver here. First, in our experience, we've never seen BLM prepare an EA or a FONSI or any additional environmental analysis whatsoever when it grants a waiver exception or modification request. From what we've seen, the grant of a waiver is more akin to a memo to the file than an interdisciplinary review. Industry's characterization of this as a robust environmental review process is not reflected in our experience. In addition, waiver of lease stipulation by BLM is just not the same as waiver of a rule by CPW. In the federal context, the BLM is being asked to waive a stipulation on a lease, essentially a contract provision to which the BLM and the operator previously agreed. Here, the Commission is being asked to waive a rule of general applicability. Also, the BLM in the federal context is the regulatory agency, the mineral owner, and oftentimes also the property owner. Here, CPW is none of those things. They're simply a consulting agency helping the Commission to fulfill its duties under Senate Bill 181. And finally, it's worth mentioning that BLM has a multiple use mandate, whereas the Commission has a mandate to protect wildlife resources from the impacts of oil and gas operations. And before I go, if I'm not yet cut off.
You are cut off, but go ahead and give us your last piece.
Well, I was just going to say, just briefly express our support for other parties' requests that the Commission establish a biological resources working group. We understand and appreciate that this is a large topic. We would request that this group be established and directed to return with recommendations within 12 months. And with that, I'll conclude. Happy to take any questions.
Thank you, Mr. Randall. Appreciate the closing, hitting on certain points. questions for Mr. Randall from Commission? Commissioner Gonzalez.
Thank you, Mr. Chair. I've got a couple of questions, but I wanted to address something you said about CPW being subjected to, or I guess the request from industry that CPW be subjected to a standardless waiver process. And I guess my question to you is, isn't the standard for CPW's determination, for the staff's determination, for our determinations, a reasonable or necessary protection? Does it protect public health, safety, welfare, the environment, and wildlife resources? Is that not a standard?
Mr. Randall.
Thank you, Mr. Chair, and thank you, Commissioner Gonzalez. That is the standard. It's the standard in the statute. It's the standard that would be met with a buffer of general applicability. What they'll be asked to do is to consider those on a case-by-case basis. So no, you're right. That's the standard that's in the statute, reasonable, necessary, would it protect wildlife resources.
Thank you, and I look forward to regulating under that standard, as I know staff does as well, and as we're doing with these rules. My next question is about the 300 to 500. You know, we've heard a lot about it, and I think there has been evidence and testimony that 500 feet is potentially beneficial. That there have been studies that we've seen that have referenced 500 feet in terms of in terms of riverscapes, in terms of the need for that, maybe not the need for that size of the buffer, but some justification for that buffer through studies. And I guess what I'm going at is the necessary standard that we're applying under these rules. Is under the previous rules, under 300 feet, under the 300-foot setbacks that previously existed, what happened, I guess, that dictates the necessity for a greater setback? I understand the studies, and I understand the benefits, and I understand the preferences that have been stated through the testimony, but I'm trying to get to the necessity of increasing that setback from 300 to 500 feet, and where that evidence has existed through the testimony or through the pre-hearing or the I guess the written comments and all the materials we've gone through. I don't know that I've found evidence to the necessity of that. So that's my question.
Mr. Randall.
Thank you, Mr. Chair. And again, thanks for the question. You know, what we've seen is that 300 feet would meet the previous statutory standard. It was necessary to meet the standard pre-Senate Bill 181 to minimize impacts on wildlife resources, taking into account the various factors that were in the law before Senate Bill 181. I think with the change in the standard, what is necessary is the possibility of doing more than that, because again, the previous standard reflected the mandate to balance protection of these resources with development of oil and gas. We heard testimony, we presented testimony that with distance comes dissipation of the potential for impacts to water quality. Those come from sedimentation resulting from erosion from these sites. It comes from impacts to surface waters from spills and releases that haven't been appropriately contained. And I think that is the basis for the federal government to consider buffers that are wider than 300 feet. And that's the basis for our request here, that doing so is necessary to protect the most important high priority aquatic habitats. In CPW's professional judgment, and in COGCC's professional judgment, they say that is what is necessary, and that's reflected in the record.
Thank you, Mr. Randall. Mr. Chair, may I ask one more question?
Please.
Thank you. I wanted to talk about, I guess there was a comment that I think you made in your closing today about industry complaints about public input. And I didn't quite get that from the testimony, so I'm not quite sure where that came from. But regardless, my question is, you know, why is the public more qualified to make inputs on wildlife than CPW experts?
Mr. Randall.
Thank you, Mr. Chair, and thanks for the question. I didn't say that they were more qualified than CPW to provide input. I just think that they might provide relevant information about resources on the ground. When I was characterizing industry's complaints about public process, that came from a statement made by the Small Operator Society as to the burden of having to go through the Commission's variance process rather than a waiver process. They said that doing so through a variance would result in a 510 hearing before the Commission. Reference to Rule 510 is a Rule 510 hearing allows the public to submit written public comments via 510 statements, as this Commission's already seen, as well as to present public comments in a Rule 510 hearing. And so I took that to mean a complaint about the duration and intensity of process of obtaining a hearing through Rule 510. So that was the basis for my comment.
Sure, and I agree that does create kind of additional burdens in terms of the process itself. I don't really see it as a complaint for the public input. I think we've heard from a lot of industry that public input is welcomed. And so we can talk about variance and waivers a little bit afterwards, or further deliberations. But we've heard from this group, and I'll turn it over to the rest of my commissioners. Thank you, Mr. Randall.
Thank you.
Other commissioners with questions? Thank you very much, Mr. Randall. We appreciate your summation. We will now turn to Preston Peak Resources for a short closing.
Just waiting for David Stewart to join. I see him.
Can everybody hear me?
We can.
Okay. Well, good morning. My name is David Stewart. I'm the Vice President of EHS and Regulatory for Crestone Peak. I would like to express Crestone's appreciation for the hard work of staff and the Commission in drafting and considering regulations that ensure the protection of Colorado's wildlife resources. Speaking for myself and for all employees and representatives of Crestone, we value wildlife habitats, and seek to protect wildlife in all aspects of our operations and our lives. It is in this spirit of value and protection that I reiterate the importance of early consultation with CPW and ask that Rule 1202C incorporate a CPW waiver process. A Rule 1202C waiver process will allow the experts at CPW to review a proposed location, ensure that the appropriate protections are in place. If as a result of pre-application consultation, a different buffer is appropriate to protect high priority habitat, CPW should be able to waive the buffer early in the process. Crestone has a long-standing history of successfully working with CPW to protect all wildlife species near our locations, and as a result has had no adverse impacts on wildlife. For these reasons, I urge you to adopt a CPW waiver in Rule 1202C to allow CPW's expertise to dictate the most protective conditions and operating practices to protect wildlife. Thank you for your time.
Thank you, Mr. Stewart, for your closing. Do commissioners have any questions? Commissioner Messner.
Thank you, Mr. Chair. Just a general question. In advocating for a waiver to 1202C and utilizing the expertise of CPW to determine proper buffering for an oil and gas location, I mean, I think I've heard from some industry folks just generally through testimony, but I just want to ask a specific question. Should a process like this be implemented, and should CPW in their analysis determine that a setback greater than the original 500-foot setback is appropriate, would this particular panel agree to that type of stipulation based on a site-specific, on-the-ground truthing analysis to that particular provision? So,
Sure, thank you for the question. Yeah, absolutely. I believe that CPW does house the expertise to make those decisions. I believe they've developed guidelines and processes for evaluation that are pertinent, and relevant, and protective of wildlife. And if it was determined that a buffer distance needed to be greater in a certain situation, I think that's valuable insight to alternative location analysis and cumulative impacts, and that absolutely would be considered for sure.
Okay, thank you.
Seeing no further questions, thank you for your closing, and we will now turn to the National Audubon Society, Conservation Colorado et al., and they have 4 minutes and 59 seconds.
Thank you.
Good morning,
I don't know that I'll need all four. Thank you. I don't know that I'll need all 459, but I'll do my best. On behalf of the National Audubon Society, Audubon Rockies, Conservation Colorado, Battlement Concerned Citizens, Grand Valley Citizens Alliance, and Western Colorado Alliance, We want to thank you for the time and attention the commission and staff have put into the 1200 series rulemaking. I want to just emphasize a few points that were the subject of a lot of discussion last week. First, the protections in Rule 1202C. As discussed by Mr. Randall, there has been a weight of recognized scientists and regulators, federal and state, including CPW and literature, to support these protections. I don't think we need to match every specific protection to exactly where it's mirroring others, but I think there has been sufficient evidence, for instance, in particular related to sage grouse. The leading scientists in this field have documented the impacts of oil and gas development in a range of at least 4 miles. You heard this from Matt Holloran, one of the leading experts on this issue. And I note that the current Colorado BLM plan recognizes the need for strong protections. It goes so far as to close the first mile around a lek entirely to leasing, and then has a second mile of no surface occupancy. We've heard some references to the 2019 amendments to these plans. I would just point out those are enjoined in part because they strayed so far from accepted science and are likely to stay that way. So I think it's important we recognize what's in place. Strengthening the protections in 1202C is merited, weakening them is not. And I would just reiterate that the Gunnison sage grouse similarly, based on its similarities to the greater sage grouse, deserves similar levels of protecting. And I think that the variance process that's in the rules right now can address the situations where specific topography or other considerations merit a different level of protection. We have a process and we can follow it. Next, on the continuing challenge over how we address biological resources, I would note that Rule 201A, which addresses the scope of the rules, actually does state that the rules are promulgated in part to, quote, protect against adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations. Biological resources can't just be ignored, and discussing them in an attachment to the statement of basis and purpose doesn't really fulfill this requirement. While we support the idea of a potential working group to address the issue, if that's on the table, we also propose that the rules include biological resources in the definition of high priority habitat. This can support the idea of a working group, leaving room for the results of that process. And as mentioned by Mr. Randall, we would support a group that was established with a mandate to return with recommendations in 12 months. Finally, I just want to circle back on compensatory mitigation. You heard a lot about this from our witnesses. Compensatory mitigation is really a last resort. We know avoidance succeeds. Compensatory mitigation may not. However, this is an important option. And so Rule 1203 should be administered with clear requirements for mitigation plans, monitoring, adaptive management, and overall transparency. Clarity on how costs are being assessed and regular reporting are key to showing that this part of the rules can actually work for wildlife. Thank you.
Thank you, Ms. Culver, for that closing. Do we have questions? Commissioner McGowan.
Thank you, Mr. Chair. Excuse me. So as to the reporting and transparency for the mitigation plans, I think in another rule series, sorry, it's all starting to blur together. There will be an annual report where we share what kind of mitigation plans have been approved and for what purpose. So do you feel we need to go beyond that?
Ms. Culver.
Thank you, Commissioner McGowan. I think what we're suggesting here is that we specifically want to see how the money is being spent from the fees that are being collected, as well as monitoring of whether the projects are succeeding, so action can be taken if they're not.
Thank you.
Thank you. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Ms. Culver. I was just curious, this was more related to some of the testimony we heard from the Wildlife and Biological Resources Coalition, but given your comments on the biological resources and the need for the definition, I was curious if you had any thoughts on some of the comments that related to the endemic plants and the additional protections that may be needed there when critical habitat has not been designated?
Thank you.
Commissioner Culver, or
Oh.
Ms. Culver.
Thank you, Chair. Thank you, Mr. Chair and Commissioner Nanjapa. Yeah, I think that including the definition of biological resources, and for instance, one of the proposals we had was to include a requirement for operators to check the data available at the Colorado Natural Heritage Program would allow us to address these plants and other biological resources. And where we don't have critical habitat identified, that will require a little more work. But I think it's something that was contemplated in using the term biological resources and should be addressed. CPW has emphasized the way that many of these resources interact with what's priority habitat. And so I think based on their summary, there could be a lot of efficiencies here. But again, we won't know that unless we check on biological resources as well.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you again for that response. And just to confirm, so in with respect to the plans, as you mentioned, so that would that apply in like the 300 series for the plans that must be submitted with alternate location analyses, and also for the cumulative impacts database?
Ms. Culver.
Yes. That would be the idea, that this data would help us develop an alternative location analysis, especially that would avoid these plants. They can't, just as we've talked about animals not being able to determine new migration corridors just because it's convenient. I think that it's even more obvious with plants. They can't really pick up and go.
Thank you.
Other questions? Thank you, Ms. Culver. We will now turn to La Plata County for a short 31-second closing statement.
I'm waiting for Lynn Paget. There she is. And I need to share a screen before beginning, Commissioner.
Very good.
Okay, good morning. We have 31 seconds, so we prepared a slide that responds to Commissioner Nanjapa's request for an additional breakdown of wells in San Miguel that Ms. Paget was testifying about. And on the left, it presents that 23 of the 30 wells are active. Given our time, that's all I can say, but Ms. Paget is available if there are any questions.
I'm looking to my fellow commissioners. Does anyone have questions? Give it to you, Mr. Iatridis. That's a wise use of 31 seconds by putting up a slide. Ms. Commissioner Nanjapa.
Thank you, Mr. Chair. And thank you so much, Mr. Iatridis, for providing this information, and to Ms. Paget as well. One of the questions I had here, knowing that we've lost some lek habitat for Gunnison sage grouse, and that we were looking at some of the declines in this area, do you have the numbers on how many of these were within a mile and greater than a mile, that breakdown from the
We'll turn to Ms. Paget for that.
Yes, thank you for the question, Commissioner Nanjapa. You can see on the slide the green sort of circle-ish blobs, and that is the COGCC's shapefile that was provided representing a 0.6 mile lek buffer. I buffered that out to a mile, which is the blue outline. So you can see where 1 mile away from the lek complex is the blue line. And these wells represent being about another half a mile to a mile away from that. So it's within it's less than 2 miles from the lek if that helps. And I did put a little scale bar in the bottom right of the slide. So offline, you can measure that yourself as well. But if you were to pick on the Dry Creek Basin State Wildlife Area square in the bottom right of the map, you can see that that square is a square mile, and you can pinch on your own screen and see, you know, how a mile lines up. But this well density occurs, we'll just say roughly within 2 miles of the LEC complex. But again, it's in the high priority habitat that is proposed under this rulemaking. So there is, you can see that the gray shadow is the 4 mile LEC buffer, which forms production areas. And the pink is the occupied habitat that is also part of this proposed rulemaking. And together, those two are proposed as high priority habitat, the production areas and the occupied habitat. And so you see that this well density is recommended under this rulemaking to be 1 well pad per square mile in high priority habitat. And we've calculated that it's up to 23 wells per square mile.
Commissioner Nanjapa.
Thank you very much, Ms. Padgett. That's very helpful. And I'm just curious, could you comment on what other sort of land alteration activities are occurring around there? Is there housing development? Is there commercial development, et cetera?
So this area is actually mostly BLM land, the Bureau of Land Management land. That's the yellow land status layer in the background there, along with some large single ownership ranches, which is the white. Most of the ranch land has already been put under CCAA, a candidate conservation agreement with assurances for the beneficial management for sage grouse. I don't have that on this particular slide, but I can provide that if that's interesting. And the state wildlife areas in blue are managed also beneficially for Gunnison sage grouse. So there is no residential development. The census data shows like population of 0 to 6 people per square mile. It's really functionally 0. This is an area that was historically mined for uranium and vanadium back in the 50s and 60s and into the 70s. But the historic data I find shows that sage grouse did persist in countable numbers even during that period. There is some low-level recreation that, you know, there are a few mountain bikers that go up north of these LEC complexes along the ridge. And currently it's hunting season. And so for about a month or so, there are hunters utilizing some of the same areas as the oil and gas wells might show.
Commissioner Gonzalez.
Thank you. Thank you, Ms. Padgett. I'm curious, I'm reading through all the notes on this slide here. Do I have this right that kind of the newest well developed here is about 9 years old?
Correct.
Okay. And then what's the average size of the well pads that are supporting these wells?
You know, that's a great question. It's an analysis I didn't get to on aerial photos, but it appears that they could be between an acre or more. When you go out there, they range in size, I'll just say.
Yeah, of course, due to topography and cut and fill and all that good stuff. Another question is, how many wells per pad are you typically seeing for these wells in this area?
So these are all vertical wells. They're not horizontal wells. So it is generally sort of one well on its own pad. There may be a coalition or, you know, combination of pads in places. You know, these areas are supposed to be gated off and not really accessible to the public. So I will say I haven't trespassed. So I would do that analysis by aerial photos mostly.
Okay. Yeah, and I think you'd be able to do it with.
Hopefully the commission has that information in-house as well.
Sure, that'll all be publicly available on the COGCC COGIS map and all that. Okay, thank you.
Thank you very much for your closing statement. We will now turn to Kendra Morgan.
Good morning, commissioners. Let me share a screen. All right. Can you see my slide deck?
We can.
Great, excellent. Ana Gutierrez with Hogan Levels on behalf of Kendra Morgan CO2. I want to get ahead of a question that might come up during deliberations, which is why is the MOU not good enough? The MOU was not developed under the framework of these rules. It doesn't contemplate the world we live in. The commission will now have regs that directly conflict with the federal regs. And most importantly, my communication with BLM has clearly stated that the proposed rule should do more to reflect BLM's jurisdiction, process, and decisions. That's why we need an exception or waiver process for federal lands. Two very brief final points. We're not asking that you replicate BLM's process exactly, because they have an entirely different regime with leases, but we ask you have a similar tool to accommodate those circumstances, and I'm happy to answer questions on that. And the last piece is you all discussed yesterday with another party the varying levels of NEPA review. The big takeaway is that no matter the level of review, species surveys are conducted to be sure there are no species impacts. And if there are, those are mitigated.
Time is up.
Thank you. I'm done.
Thank you. 23 seconds runs quick. Questions? Okay, thank you. Seeing none, we will move to Small Operator Society.
Thank you, Chairman Robbins. Ms. Larson, is Dale Ratliff in the panel?
You will get Mr. Ratliff in.
Thank you. He'll be delivering our remarks today. Thank you very much.
Okay. Ready? Mr. Ratliff, you have the floor for 1 minute and 44 seconds.
Thank you. Good morning, Commissioners. My name is Dale Ratliff on behalf of CPX Peons Holdings and the Small Operator Society. We would like to offer the following with our remaining time as follow-up to Commissioner Q&A during the party presentations. First, in response to questioning we heard regarding the BLM waiver process, BLM RMPs state that BLM may require one or a combination of the following: plans of development, field surveys, mitigation proposals, or some form of environmental analysis. The information should show the conditions on the ground have changed or the resource is not present, and that approval won't cause unacceptable impacts. We envision the consultation process to require similarly scalable information, and we envision the determination to be similar. Is the resource present and in what condition, and will granting the waiver cause unacceptable impacts? Second, we do understand that the waiver process will not provide operators with 100% certainty of ultimate permit approval. The point of pre-application consultation is for an operator to understand whether it's ill-advised or futile to proceed with preparing the intensive permit application. And it's not just about ease versus burden, and it will not remove CPW or commission authority or remove public involvement. The waiver will need to be analyzed and approved as part of the permit decision. The pre-application consultation and waiver process is also better equipped to handle the application of the new rules to the many existing locations the new buffers will now apply to. Third, the proposed pre-application consultation and waiver process for intermittent and ephemeral streams demonstrates that CPW understands that critical resource values can be adequately protected and subject to consultation and waiver. This determination supports a pre-application consultation and waiver for all of 1202C. And finally, we ask that any relief granted for 1202C1R native aquatics be bundled with 1202C1Q cutthroat trout. Cutthroat trout are a native fish, and as discussed, the record has not shown that the existing buffer has inadequately protected the species over the last 10 years. Thank you.
Thank you. Do we have questions? Thank you very much, Mr. Ratliff, for the closing. We will now turn to Western Resource Advocates.
Ready?
Yes.
Okay. So this commission is charged with protecting values such as water supplies, water quality, wildlife, plants, recreation, and scenic beauty. The record establishes beyond a doubt that the way this is done is by establishing considerable buffers around not only some fisheries, but all small streams, wetlands, and riparian areas. Plus, the fact is that in Colorado, federal agencies have established buffers as necessary to protect all Colorado waters without shutting down the oil and gas industry. This is what a buffer means. Given the value and sensitivity of Colorado's waters, the assumption is that there will be no development in and around these areas. If the operators propose to develop in these areas, the proposal will be made before the public and the commission with evidence in the record, and the decision will not be made ahead of time without public participation. It is completely within the discretion of the commission to adopt such an approach rather than a case-by-case approach as necessary to protect SB 181 values. Second, the record confirms that there are vast areas outside of high priority habitat where oil and gas development is already having a significant adverse impact on wildlife and special status plants. There is almost complete agreement that invaluable sources of information on the location of Colorado's vulnerable plants and wildlife exist, including from CNHP. We ask the commission to encourage operators to confer with this data sources and use this data to inform their planning. This is simply done by requiring operators to disclose whether it has consulted these information sources, what the results are, and what, if anything, the operator proposes to do in response to this information. Particularly where climate change and development pressure are already taking a significant toll, meaningful protection that is conservative and proactive is necessary. If we wait to do more to protect Colorado's waters, wildlife, and plants until data shows these resources are ailing, it will be too late, and the SB 181 mandate will be impossible to fulfill. Thank you.
Thank you, Ms. Walker. Questions? Commissioner McGowan?
Mr. Chair, thank you, Ms. Walker. So as to the comment, around public participation and the ability to comment on a variance versus a waiver, the timing is different, but both still have to go to the commission, and there's an opportunity for input and comment. So could you explain a little more to me why you think that the waiver process would not allow for public input opportunities in front of the commission?
Yes, so the part of the concern is that the decision will essentially already be made, right? So there's already a position established on the decision before the public has the opportunity to participate. And then the other issue, I think Mr. Randall spoke this, is that, it's sort of the robustness of the process and of the record. So the idea is that the public should get involved as early in the process as possible. And this is not unusual. It's a tenet under NEPA as well. And that it should do so before decisions are made, or at least close to being made. So if CPW is making is conferring, say, this example was raised, I think, already today. So CPW is confirming over whether, something is still high priority habitat. Well, then in a sense, the decision is close to being made already, whether it is or not. And the public loses that ability to influence decision makers, including CPW, before those decisions are made.
Commissioner McGowan?
Thank you, Mr. Chair. So if there were an opportunity for input during the waiver process, would that address some of your concerns?
Yeah, I mean, it's kind of vague, but certainly the idea is that you'd want you'd want a record, you'd want evidence and the opportunity to introduce evidence into this decision-making process. So if all those things were taken care of, sure.
Thank you.
Thank you, Ms. Walker. I believe now we're going to bring in Mr. Jewell on behalf of TEP.
Thank you, Chair Robbins. Thank you again for your time. Michael Jewell on behalf of Terra. Welcome to the final substantive week of the rulemaking. It's like an early Thanksgiving gift, right? We're calling our discussion of not only how much acreage that Terra operates in that is federal, but also the nature of our federal leases. They have carefully crafted stipulations that accompany those leases to protect wildlife. They are laser focused. They create an operational rhythm that harmonize with the wildlife that call the peons home. Many, if not most of these stipulations provide protections that exceed the distancing requirements found in Rule 1202C. Like you, we encourage flexibility for efficacious solutions that are efficient for staff to implement. Therefore, Terra proposes a caveat be carved into 1202C that recognizes that an agreement between BLM, CPW, COGCC, and the operator can be reached on live leases in lieu of merely following the setbacks proposed by the rule for high priority species. You demonstrated receptivity to Terra's request to coordinate with BLM, and now we respectfully request that these 1200 series rules encourage this coordination with CPW and BLM. Together with the industry's request, Terra echoes that the 1202C waiver process with CPW only proves that agency collaboration can produce results in protecting wildlife. Thank you as always for your time and collaboration.
Okay, thanks. You were over time.
Thank you.
Questions? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Jewell. Just want to make sure I heard you right. Did you say that the majority of your leases have setbacks further than the setbacks proposed in 1202C?
The reason why I said waiver at the end, and I'm talking about having an agreement, is that a lot of these stipulations will either have a setback or something that is a little more custom tailored. For instance, I used the eagle circumstance last time. Whereas you may have a half-mile buffer, if you will, from the eagle's nest, a stipulation might have you can't operate at all on the lease for the key time that the eagles are nesting. So that actually goes beyond what just a setback would have and is more carefully crafted for protection of the eagles. So what we're suggesting is when we have those stipulations in place, if we can collaborate with CPW, with you and BLM and sign off on following that usage instead, I think that's better for all involved, especially wildlife.
Thank you.
Commissioner Gonzalez.
Thank you, Mr. Jewell. And as you're reading into the rules as currently drafted, is that that opportunity for more substantial COAs, does that exist?
Mr. Jewell.
COAs could exist for that, but I think the point we want to bring home is have a constant communication and process with CPW and BLM particularly to make sure we're always using the best science, and there's a presumptive realization that if it's in the lease, it's probably based off of something that works for all. So we want to just take that and use that instead of reinventing the wheel with a COA each time a permit is offered.
Okay. Thank you, Mr. Jewell.
Other questions? All right. Thank you, Mr. Jewell.
Thank you.
We will now turn to Noble PDC and Oxy for Mr. Dave Neslin. And Ms. Larson, did Mr. Neslin get any additional time from industry?
He did. There was 32 seconds remaining, so Mr. Neslin has a total of 43 seconds.
Mr. Neslin, make good use of your time.
Commissioners, Dave Neslin on behalf of Noble, Occidental, and PDC. We urge you to leave all of the big game habitat in Rule 1202D as proposed by the staff and CPW. Big game habitat is pervasive, so NSO requirements would put much of the state off limits, particularly when combined with setbacks in other rules. The 3% threshold is not a meaningful off-ramp or limitation. Most of the DJ Basin already exceeds that threshold due to historic development. Under Rule 1202D, CPW will consult on all sites in big game habitat and can recommend avoidance or other mitigation as appropriate. This is appropriate for big game habitat because of the inexact scale of the mapping and the lack of mapping for mitigation routes and features. CPW's slide indicates that mitigation corridors can include broad and dispersed networks of land, which would greatly magnify the effect of a uniform NSO requirement. Thank you, commissioners.
Thank you, Mr. Neslin. Commissioner Gonzalez.
Thank you, Mr. Chair. Thank you, Mr. Neslin. I'd like to piggyback on a couple questions that were asked to a couple different groups here in closing today. The first one is, how does this group view the inclusion of public input into the potential CPW waiver process?
Yeah, thank you, Commissioner, for that question. I'll just speak for myself. The public is going to, accepting that CPW grants a waiver, that in and of itself does not authorize the approval of the oil and gas development plan. You commissioners have to approve the oil and gas development plan through a hearing process, and the public is going to have an opportunity for input, both written and oral input, in the approval process. So I don't believe that a separate process for public input needs to be included in the waiver negotiation or discussion itself.
So if I understand you correctly, are we saying that the public can offer input during the OGDP process on any part of the OGDP decision-making process, whereas a waiver on the CPW waiver, or as an input on the CPW waiver would be just narrow to that waiver part of the process?
Yes, as I read the rules, that would be correct, Commissioner.
My next question is, does this group support more substantive COAs and the potential for a bigger setback if ground truthing justifies, kind of how that habitat is mapped and marked?
Yes, Commissioner, as part of a case-by-case review process, I believe that could lead to no COAs or any number of COAs, or in appropriate instances, a broader setback. But it should be a case-by-case process that looks at the particular facts and features on the ground. The CPW clearly has that authority under proposed Rule 309E.
And then one more question. This goes to the same question I asked Mr. Randall about kind of necessary and reasonable. And with that, notwithstanding, the necessary component of it, do you think that the 500-foot setback or the setbacks that are outlined in 1202C would be reasonable if they had a CPW waiver, pre-consultation, pre-application waiver attached to them?
Is this for the aquatic species?
Yes, for the aquatic species, for the QRNS, the cutthroat, the native, and the sportfish.
I think we would agree with the industry that we don't believe the record as it exists now supports the 500-foot setback, the increased setback for that purpose. If you were nevertheless to expand the setback as set forth in the proposed rules, then again, we also believe agree with the industry that some form of waiver is appropriate to be included in Rule 1202C. And there's been a great deal of discussion about the differences between waivers and variances. And I'll give you my perspective as someone who's, led agencies and participated in agency proceedings for decades now. And that is, you want the process to be as focused and as efficient as possible. What's clear is the operator needs to work with CPW to evaluate the proposed project, the specific landscape, and whether a setback and what kind of setback is appropriate and necessary in that instance. And that needs to be focused on that particular situation. So I think that answers your question.
Thank you, Mr. Neslin.
Thank you, Mr. Neslin. Commissioner McGowan.
Thank you, Mr. Chair. Thank you for your additional 45 seconds, Mr. Neslin. So since we're playing pretend scenarios, wondering how you would feel if there were hard setbacks, 500 feet for perennial streams, 300 feet for intermittent and ephemeral, with a variance opportunity available.
Mr. Neslin?
Commissioner, that's a difficult question for me because I haven't discussed those scenarios with my clients. So I can only, my clients, so I can only offer you my perspective. And that is applying a 500-foot setback. Well, let me think for just a second so I can offer in a way that answer in a way that's helpful. I don't believe that the industry's criticisms and questions regarding the record differ materially whether we're talking about an intermittent or ephemeral stream or a perennial stream. I think the industry has raised questions about the justification for expanding the setback distance, whether it's ephemeral or intermittent or perennial. I'll reiterate that if the proposed setbacks are adopted in 1202C, then it seems to me very important that 1202C include a waiver process, as you suggested in your hypothetical. You know, again, I think a waiver allows you and CPW and the operator to focus on the real issue, which is this in fact wildlife habitat, meaningful wildlife habitat, and what is necessary to protect that wildlife habitat? What kind of setback is necessary to protect that wildlife habitat? And that's a discussion that should be led by biologists, which it would be through a waiver process and discussion. I think a waiver would also be a less formal proceeding, and I think that is an advantage. In contrast, the variance process, which we spent a great deal of time talking about a month or two ago, that's going to be a adjudicatory formal process led by attorneys, not a consultation led by biologists. I think it's a less focused and less efficient process for this purpose. So again, I would emphasize the need for a waiver if you expand the setbacks for aquatic species as proposed in the draft rules.
Commissioner McGowan, then Commissioner Najapa.
Thank you, Mr. Chair. So as a follow-up, if we were to head down the waiver path, I do think there's some value in the feedback from folks that are worried that if there's an opportunity for folks to participate at the front end, it almost feels like a done deal by the time you get to the end, so to speak, and you get in front of the commission. Do you think industry would be supportive at minimum, making sure that a relevant local government would be able to participate in the waiver process? Because I think we have heard testimony that from a statewide level, there's kind of limited knowledge sometimes with CPW, and that a local government might have some important information about habitat and what's happening in that habitat. And I'm wondering how you feel about that. Or sorry, not you, but yeah.
And again, I can't speak on behalf of my clients because I haven't discussed that question with them, and I can't speak on behalf of industry generally. But speaking only for myself, Commissioner, I can see that or I can anticipate that in some instances, providing an opportunity for the relevant local government to participate could be helpful. They might have some particular information regarding that specific site that's useful for CPW and the operator to hear. And it seems to me they could participate in a way that is efficient and doesn't distract from or unduly complicate the process.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Commissioner McGowan. That last bit of your question was pretty much exactly what I was just going to ask. But just to piggyback on that a little bit is, so with this hypothetical of a waiver that would allow for public input, and if that went beyond the relevant local government and was just general public input up front, you know, the idea there is that if we're talking specifically about this as a CPW waiver, that can be discussed, that we're talking specifically about the wildlife and environmental issues, because we have a lot of robust rules for the public health, safety, welfare issues in the Ogdp, and that would be the process that, or those would be the other factors that we would be, you know, considering kind of towards the final end of the decision. making sure that we've upheld all of that. But up front, you know, these wildlife and environmental issues would, you know, could be a reason for a change in the location, or some other alternatives being needed to be considered. So just curious again, to get your thoughts on that idea of having that kind of public input, specifically on the wildlife and environmental side of things up front, knowing that there's even the additional public input, you know, with the OGDP process in general.
Commissioner, yes, Commissioner, that's an excellent question. Thank you. I reiterate that I can see scenarios in which having the relevant local government participate in that discussion could bring meaningful value. Maybe the local government's got particular information that's relevant. Maybe the local government has already evaluated this or is evaluating it through an alternative evaluation or something. I'm less enamored with the idea of broad public input into this waiver discussion. And I say that for a couple of reasons. It seems to me that this needs to be a discussion focused on the habitat value and the protection of that habitat value. And that's, I think, largely a biological discussion. And for the same reason, I wouldn't want to see attorneys leading that process. Respectfully, I don't know that the public in general is going to add a lot to that discussion. There will be transparency because, again, all of this will have to be presented to your agency, to the commission. The commission will have to review this, and through your 500 series rules, there will be opportunities for the public to both comment and to participate through the hearing process in writing and verbally. And it's also important to remember that in addition to your process, because this goes to citing, and Senate Bill 181 gives local governments a say in project citing. In fact, we've argued it gives them a preeminent role regarding project citing. There will be some kind of local government process regarding the citing of the project, and the public will have an opportunity to participate in that process as well. So there's going to be lots of opportunities for the public to participate in the process and to raise a whole myriad of issues and potential concerns. I think this is focused specifically on the 1202C issues, on the habitat value and the protection of that value. And again, I think that's not so much a public notice and comment issue as it is a technical issue involving wildlife specialists.
Very good. Thank you, Mr. Neslin. We will now turn to
Thank you all.
The closing statement from the Western and Rural Local Government Coalition. Good morning, Mr. Jacobs. I see you and Mr. Nguyen and Mr. Weaver. Is that your panel?
No, we need Mr. Lepore and Mr. Pedersen admitted to participate in our closing. Thank you.
Okay. We're working on that.
Very good.
We're still waiting on Mr. Pedersen to unmute and to visualize himself if he so
Yes.
desires.
Thank you. Great.
Very good. The floor is yours.
Thank you. Good morning, commissioners. WRLG, the Mesa Moffett Rio Blanco Counties Party Group, and the Logan Morgan Yuma Counties Party Group are pleased to focus on a few remaining issues of significant concern with staff's and CPW's recommended 1200 series revisions. So without further ado, here's Matt Lepore to start our closing.
Thank you, John. Good morning, commissioners. I think the big question is, what are we all going to do next week? Hope you have some R&R planned. And in the meantime, I would like to begin by reiterating briefly WRLG's top 3 asks. Those are shown on the slide in front of you. We would ask that you revert the NSO buffers around 1202 C1R and C1S to 300 feet. If you are disinclined to do that, we would ask that you have a waiver exception process for the 12021C buffer requirements. We'll show you that red line later. We would ask that you allow waivers under 1202C for oil and gas operations on federal lands with approved federal land management COAs. We also support other stakeholders who have requested a 1202C general waiver provision, and we would ask that you adopt 1202D as proposed by staff as it relates to big game. With that, I'd like to spend a couple of minutes talking about the Ogdp process that is so integral to all of this. For every oil and gas development plan submitted in high priority habitat under your proposed rules, a operator will have to consult with CPW under Rule 309E2A. They will have to conduct an alternative location analysis pursuant to 304B2, and they will have to submit a wildlife mitigation plan under 120B1. The consultation and the ALA process are both intended to identify the location that best avoids potential adverse impacts to wildlife, while the consultation and the mitigation plan are intended to ensure that impacts that cannot be avoided are minimized or mitigated. In Western Colorado, the prevalence of high priority habitat, and that includes 1202C and 1202D, will mean that there will be a consultation, an ALA, and a wildlife mitigation plan on nearly every Ogdp submitted. With respect to aquatic species habitat buffers, a consultation will likely be required just to establish the ordinary high water mark and where that buffer zone would begin to be counted from. Mr. Pedersen will explain more scientifically in a minute that an NSO without waivers or exceptions is unprecedented within the scientific literature and the resource management plans that are in the record before you. That said, regardless of whether there is a hard NSO buffer, CPW has the right to recommend that a site be located farther away than the buffer zone requires, to recommend appropriate conditions of approval, or to recommend that the proposal be denied outright. And that answers some of the questions that you have asked other stakeholders here this morning. So we think all of those things are on the table in the site-by-site analysis. At the same time, if CPW agrees that a location within a proposed NSO buffer, subject to appropriate COAs, is the best location, a waiver process would be no less protective than would a variance process. The only difference is procedural, in that the variance requires an additional separate noticed hearing with the added burden upon staff, CPW, the commission, and the operator. I think you've talked about some interesting ideas about how to bolster that waiver process, if you will, and we'd be happy to talk further with you about that. Finally, as we noted on Friday, the final decision on siting always rests with the commission. And if you decide that CPW has gone astray, you have the right to deny that Ogdp. On the slide now in front of you, we have our 2 asks for Rule 309E5D for 1202C, that CPW may waive the high priority habitat 500-foot buffer based on site-specific conditions if that's the way you go, and that CPW may waive in writing the application of, and the director may grant an exception to 1202C for oil and gas operations on federal lands with an approved relevant land management process. With that, I pass the baton to Eric Pedersen.
Eric, we're not hearing you. If you could pause the time, please. Thank you.
Can you hear me?
Now we can hear you.
Okay. Thank you, Mr. Lepore. Good morning, commissioners and Director Murphy. I would like to provide a few examples to illustrate why a waiver with conditions of approval process is extremely important to add to 1202C. The extensive literature reviewed and provided by staff and CPW, and also oral testimony from CPW's own biologists, indicate that a range of aquatic buffers is appropriate. We reiterate and ask the Commission to agree with our assessment that based on the science and data provided in the record, and based on the testimonies we heard from CPW's own biologists, that a rigid one-size-fits-all 500-foot buffer is not appropriate. It cannot be overlooked that all of the management plans referenced in support of a 500-foot aquatics buffer, but which in reality did not support such a large buffer, also provided an early process for waivers and, more importantly, site-specific review and meaningful conditions of approval to ensure impacts to aquatic resources were not realized. The current draft 500-foot rigid NSO without waiver and accompanying conditions process is unprecedented and lacks support in the record. 2, the practice of reviewing site specifics, conducting impact analyses based on real-world conditions, and then allowing within the existing rules for a potential waiver with enforceable conditions of approval is a standard tool very effectively employed by land management agencies and CPW during their consultations. Waivers without stipulations and conditions of approval are extremely rare. Waivers are virtually always accompanied by timing steps, specific BMPs, and or monitoring to ensure a variety of wildlife resources and habitats are protected. One real-world example, which was a federally regulated project, had a bald eagle nest within 400 feet of an access road. Prior to allowing a rig move to occur, the BLM and Fish and Wildlife Service required baseline monitoring by a third party to determine existing road noise levels, and then monitoring of bald eagle behavior during the rig move and other higher traffic events during the drilling activities. If the eagles showed signs of agitation, then the rig move and other noisy traffic events were to be canceled until the eaglet fledged. This exception occurred with clear conditions assuring wildlife protections, and we believe this is one illustration of why waivers should be part of the toolbox in 1202C and how they can be effectively applied. Another example would include re-entering an existing well pad to add new wells within an aquatic buffer, where CPW should have waivers as a tool to encourage an operator to simply add new wells to the location instead of building a whole new pad and disturbing an additional 2 to 4 acres for the new well pad, not to mention adding access roads and pipeline impacts as well. As we have testified, BLM has an exception, waiver, and modification process. A real-world example of how this worked well to greater wildlife benefit occurred when an operator wanted to construct a new pad within 1 mile of a lek, and the BLM allowed this to proceed as the location would not have any meaningful impact to the lek due to local topography, creating both visual and elevational isolation from the pad, such that threats to the lek were non-existent. In another real-world example, with an existing well pad location within a wildlife NSO, the BLM placed, and CPW agreed to, a seasonal timing restriction COA on the permit to fully avoid wildlife occupational conflicts, but allowed new wells to be added knowing the much higher protective value of preventing a new road, a new pad, and pipes to be constructed outside of the NSO area. Earlier today, we heard testimony from Audubon regarding the stripping of sage-grouse protections and that the 2019 revisions are enjoined. This is partially correct. However, we feel it's important for you folks to know that in Colorado, the extent of the changes to the 2015 RMPA is that areas within 1 mile of a lek are now open to leasing with a strict NSO. In this case, the BLM believed that minerals underneath a lek could be reached through directional drilling without impacting the surface within 1 mile of a lek. That is the extent of the changes in Colorado. In other Western states, there were more rollbacks surrounding grazing, mining, oil and gas leasing, and priority and general habitats, and the court's injunction order found the BLM did not adequately analyze those impacts. Thank you for your time. Kirby Nguyen will now provide additional testimony on behalf of WRLG.
Thank you, Eric and Matt, for providing great examples why we believe waivers with conditions really should be a tool in the 1202C toolbox, including for grouse and aquatics and raptors. One on a different topic for compensatory mitigation, we appreciate the Commission's expressed interest in our suggestion from Mr. Comstock the other day that allowing conservation districts to serve as fiscal agents for compensatory mitigation projects could be a great option. We would look forward to conferring with the Commission and staff on how that might work. I also would like to restate our position that we do not support proposals to shoehorn general riparian setbacks into this late stage of the rulemaking. The record simply does not exist to navigate such a big lift without creating a landslide of negative unintended consequences. We do support and look forward to seeing a technical work group study the issue of general riparian setbacks and seeing that group make recommendations for a future rulemaking. Lastly, here's the last look at our proposed redline language for a general 1202C waiver with conditions process. We believe the record supports, and this may be the most appropriate approach to give CPW the tools they need in their toolbox to provide the most comprehensive recommendations to the Commission. That should include waivers with conditions, which the Commission always retain authority.
Over time.
Oh, thank you. I'll wrap it right up. Anyway, the Commission always has the ability to deny these sort of things. Lastly, you could also add to the SBP to indicate whether you think such a waiver would be commonly, uncommonly used. Thank you very much. I apologize for going over.
Commissioners, are there questions for this panel in closing? Commissioner Najapa.
Thank you, Mr. Chair, and thank you all for your comments and testimony. Mr. Pedersen, I wanted to just get clarity on the BLM rules and changes. We've heard about this a little bit, and I looked into it a little bit, but I just want to make sure that I'm clear. So I believe what we had heard was that in 2015, that leasing was disallowed within 1 mile of a lek, and then there was an additional NSO 1 mile beyond that. But what you're saying is that with the 2019 changes, the leasing could occur within 1 mile of a lek because it could be accessed from outside of that area. Is that what was changed in 2019? And then how does the additional 1 mile NSO fit in?
So that's correct. Essentially, if you imagine, there would be these leases with little donut holes where you couldn't access the subsurface minerals. And in, I believe starting in 2017 is when it first was proposed that, why couldn't we access those minerals through directional drilling? There's still a surface NSO. You still can't get within 1 mile of the lek. All those rules are still the same. PHMA, all those STIPs are still the same. And what was the second part of your question?
So my understanding was that there's an additional NSO 1 mile beyond. So the 1 mile beyond, around the lek was initially prohibited from leasing, and then there was an additional 1 mile NSO. At least that's the way I understood it. So I'm trying to understand, did that also change, that additional mile NSO, given that you could now access the minerals directly under the lek, or at least that's now been reopened for leasing?
Right.
Correct?
I don't believe there was a 1 mile NSO and then another 1 mile NSO. I think it was just always a 1 mile NSO. I think.
Okay. I think we heard from, trying to remember which group it was, but it was, her name was Chris, and I forget her last name, but she was a former BLM employee. I believe she said that it was the first mile was, there was a prohibition on leasing in that first mile. Then the second mile was NSO. But I do want to make sure that I've got that correct. If that's, I see John Messner, Commissioner Messner nodding his head, but maybe we can get some clarification from staff on that. But it sounds like you don't understand it to be that way. And so could you just clarify what your current understanding of the way this works is?
So outside of the 1 mile NSO, everything is still priority habitat management area, which has, you know, the 3% disturbance caps or the 1 facility per square mile disturbance cap. Still has all the timing steps. You still have to go through the process that essentially shows the BLM there is no meaningful impact to sage grouse habitats. So your PHMA and the steps that still are there with PHMA are probably a bigger protective mechanism than a simple 1 mile NSO around a lek, in my opinion. I mean, that the 1 mile NSO is what it is. I think all the operators know that, yeah, you're not getting close to a lek anymore. But those PHMA steps are, I feel, if not more important, than just as important.
If I may, Commissioner, I just want to be clear. I think Eric was sort of between there. Just to be clear, there's only a single 1 mile NSO. There's not an additional one outside that.
Commissioner Messner, I believe you had raised your hand.
Thank you, Mr. Chair. I did have a couple questions. I'll start with, well, let me start with Mr. Lepore and just talking about the general application process. And so one of the things that I'm struggling here a little bit with is, as an operator is looking at submitting an OGDP and they're looking at alternative site analysis and they're doing the due diligence in order to be able to provide and submit that application, and consulting with CPW through that process, particularly through the ALA process. And so having that initial pre-application consultation with CPW that some parties have indicated doesn't happen, but it certainly does through the OGDP process. As you're doing an alternative location analysis, I'm trying to figure, I guess I'm trying to understand how many sites in this analysis are going to be deemed appropriate if they don't meet the rules that are provided, you know, to be able to follow. Do you know what I'm saying? So if you're looking at the rules and you're doing an alternative site analysis or alternative location analysis, and you know that you've got these different buffers and different setbacks and, you know, all the different things that are involved in the rules that would come into an analysis, how many instances will there be where you're like, no, it actually, the best place is, you know, 250 feet from, you know, this water body?
So, thank you, Mr. Chair, and thank you, Commissioner Messner. I mean, a little bit hard to answer, I suppose, on a purely hypothetical basis, but I'll just tell you, you know, what I have seen in my experience, which is siting oil and gas locations is a challenge for a whole lot of reasons, and the Commission's rules are just one set of those reasons. There are, you know, where do I have surface access rights? What is the topography? How far can my wellbore reach? Do I have a surface owner who wants me on the surface? All those things are, you know, part of this calculus. But by and large, I don't think an operator has a big incentive to want to be someplace where the Commission has indicated they ought not be. So my experience is they will seek to avoid those places as best they can. A potential advantage of, you know, we've got the CAP process now, which I'm a huge supporter of. I think there are going to be fewer opportunities for big caps than we might all wish. So let's look at the sort of the next size down that's not a full-on cap, but it's a multi-location type development. I can see that scenario where I can keep, you know, 4 of these or 5 of these different pads outside of any buffer zone, or, you know, well mitigated within a buffer zone. But to get to the minerals, you know, there's 1 or there's 2 that I need to seek a variance for, or a waiver for, or it's inside that buffer. I think because of that multiplicity of variables and factors, that's one reason we're all kind of leaning towards, or I guess not everybody, but the best outcome, the best management tool is one that is site specific.
And let me ask just a little bit of a follow-up to that one. So in that pre-application conference with CPW, in order to be able to do the ALA, I mean, wouldn't there be some ground truthing in that process in order to determine whether it's necessary or reasonable to put a oil and gas location, whether it's even worth trying to pursue a variance at that point based on the ground truthing consultation in the ALA process?
Yeah, thank you, Mr. Chair. I think you're spot on, Commissioner. I think that's exactly right. I think that's largely what happens today is operators are engaged with CPW, explaining, where their development plan is and what the landscape is and so forth. And I guess I can't say from personal firsthand experience, but I assume that at times CPW says, yeah, that's a really bad idea. Look somewhere else.
And so, I mean, I think this is where I've scratched my head a little bit, because in that circumstance where you do have a pre-application conference with CPW in order to be able to do the ALA as part of the OGDP, and CPW has ground truth the situation and has determined, what the situation is there, then, and you've done your ALA, I mean, it seems like there's a very narrow slice of situations that would require either a variance as proposed or a waiver should that process be incorporated. I mean, it just doesn't seem like a very significant number that we're talking about here. And I think the slide by Ms. Gutierrez, previously that indicated the waiver process from a STIP in the federal process is a very rare instance. And so I'm trying to understand, kind of quantity here that could be, considered.
If I may, Commissioner, I think I'll step in here. One thing, I think Eric gave a good example. You've got myriad cases where you have existing well pads all over Western Colorado. They're going to be inside potentially the 300 feet or the 500 feet. You've got the pad there, and it's going to be common that the CPW's best recommendation to you may well be, you know what, let them add 3 wells to that existing pad there instead of scratching up another 2 to 4 acres plus roads and pipelines, et cetera. I mean, there's just an untold number of situations where CPW on the ground looking at it, and we can sit there and spitball all the different exceptions, but there's a lot of situations that are going to come up. And having a waiver as a tool, not as a guaranteed outcome, but as a tool in the toolbox, it just makes a whole lot of sense versus blocking that out completely for such a broad suite of habitats for which the mapping needs work. And frankly, the on-site situation, like existing sites as good as any, dictate that it makes more sense to drill a well where you already were than to start anew somewhere else.
So that's talking about existing stuff. So I appreciate that. Let me just ask one more question if I could. And this is trying to understand in the very rare waiver of STIPs in the federal process, and Mr. Pedersen, maybe you're the ones to answer this. What is the public engagement portion of that?
So in order for the BLM to issue like an exception or a waiver, earlier we heard some testimony that said, well, there's never any NEPA review. It's, it's this black box. But essentially all the initial determinations and conclusions of the initial environmental assessment that were done cannot be voided or changed by the waiver. The whole waiver process with the BLM is that this waiver is not going to have any meaningful or appreciable change in the determination of those environmental assessments. There's still going to be the same environmental impacts, same wildlife impacts. That's the whole point of the waiver process with the BLM. It's
So in that initial analysis, though, there's some public comment period.
Oh yeah, absolutely. Yes.
So the public have been able to get engaged specifically on that situation, and also in the waiver process.
No, not in the waiver process, because usually it's
just in the initial analysis.
Correct. Yep.
Okay. Thank you.
Commissioner Gonzalez.
Thank you, Mr. Chair. Yeah, and we talk a lot about the alternative location analysis, and we have, in several rule series and its applicability. And I think one thing that sometimes, as it appears, is that, or I guess something that I think that perhaps this group could acknowledge, is that sometimes there is not an alternative location. Sometimes there is one location that's available. And if that location does not adversely impact the resources in question, the subject resources, and does protect public health, safety, welfare, the environment, and wildlife resources, under an alternative location analysis, if that is the appropriate one within a buffer zone, why wouldn't we be able, or why shouldn't the commission be able to move forward with that? I mean, I guess I'm not asking the right people that question, I suppose, because I think I know the answer. But Mr. Lepore, I see you kind of responding to my question there. Can you just be clear that there's instances where there are no other alternative locations available, and that a location may be within a buffer zone that may very well, through a waiver process, fit what we're trying to accomplish as a regulatory body?
Mr. Lepore?
Yeah, thank you, Mr. Chair, and thank you, Commissioner. I think that's, yeah, you're right. You're absolutely spot on. And even if there was, in my view, there will be circumstances where the best site of those available, whether it's only one or still there are others, the best site still could be within that buffer. And the bigger you make the buffer, the more likely that is the case. I actually, honestly, we've been dealing with setbacks for a very, very long time now, in different contexts. And the reality is there is no perfect number. And the bigger you make the setback buffer, the greater likelihood is that you're going to trigger a need for this waiver variance process. What I hoped to illustrate in my initial remarks was that you have a robust process in place already to avoid, minimize, and mitigate. So I guess, Commissioner, if you have a 500-foot buffer and the best site is within that, you end up needing a variance or a waiver process.
Thank you, Mr. Lepore. Mr. Pedersen, did you want to?
Yeah, I just wanted to clarify something for Commissioner Nanjapa. A colleague of mine just texted me regarding the 2-mile buffer. So there is a 2-mile NSO in general habitat management areas outside of priority habitat management areas. So there is a few situations in Colorado where there are LECs located in general habitat. It's only a handful, but there is a 2-mile NSO around those LECs in general habitat management areas with waivers and exceptions. I apologize for interrupting.
Commissioner Nanjapa?
Thank you. I had another question also for Mr. Lepore on the line of questioning from Commissioner Gonzalez, but thank you very much, Mr. Pedersen, for that response. And so the general habitat management areas, is that truly just a general habitat consideration for all wildlife? It's not specific to sage grouse, or can you, I just want to better understand that designation, general habitat versus priority habitat.
So the priority habitat management is the best sage grouse habitat. Mm-hmm. General habitat management areas are not quite as good, but you do see some sage grouse use in those areas peripherally. And like I said, there's a couple LECs in the entire state that occur in GHMA. So it's just specific to sage grouse.
Okay. And so you're saying, just again, to make sure that I got that right, you're saying there is still a 2-mile a 2 mile buffer, but it's, if I understand again correctly, it's the 1 mile for leasing around a lek and then a 1 mile NSO beyond that.
I'd have to dig in and see what the steps are for leasing in GHMA around a lek.
Okay, and then, but then you're saying the difference in priority habitat was what?
Priority habitat is the best habitat. General habitat is still occupied by grouse, but just not as much. It's not as good.
But what are the limitations in the priority habitat? What's the NSO requirement?
It's there's a 1 mile NSO with BLM with exceptions and waivers, mostly just for like if you have an existing pad, or in the case of like the parachute Peons Creek where you go a mile and you drop off a 2,000-foot cliff, you know, essentially you have to be a non-habitat and there has to be no meaningful impact to sage-grouse habitats or sage-grouse if you're within that 1 mile of a lek. And then outside of that in PHMA, there's a number of timing steps, reclamation requirements. There's a 3% disturbance cap, which includes wildfire. So if a wildfire comes through and burns up a bunch of sagebrush, you're out of luck. So, and that's in priority habitat management areas.
I might add just on that 1 mile lek, the BLM very specifically, I mean, this is what they do. And the waivers they apply are really to the lease stipulations, not to the individual site. But for when you're 1 mile, within a mile of a lek, you're open to leasing subject to an NSO, which says exceptions or modifications may be considered if in consultation with the state of Colorado, it can be demonstrated that there is no impact on greater sage-grouse based on one of the following: topography, areas of non-habitat that create an effective barrier to impacts, like we testified previously. No additional impacts would be realized above those created by existing major infrastructure. For example, a highway is what they actually cite. And the exception or modification precludes or offsets greater potential impacts if the action were proposed on adjacent parcels. For example, due to land ownership patterns and some other issues. So they definitely have the waivers, the exceptions and modifications available on those leks.
Okay, thank you. Appreciate those responses from both of you. Yeah, that's helpful. And so then, Mr. Lepore, just to follow up on that line of questioning from Commissioner Gonzalez, along the same lines, given that there is the requirement already for ALA within high priority habitat, and that you may end up with the best location from the operator's perspective that is within this buffer distance, with the CPW consultation in seeking some sort of waiver or even in the variance process, there is an understanding still that there could be a denial altogether. Is that correct, and you accept that outcome?
Yes, ma'am.
Okay.
Yes, we do.
All right, thank you very much.
Other questions for the panel? Commissioner Gonzalez.
Thank you, Mr. Chair. And I appreciate the kind of the criteria that Mr. Nguyen just kind of rattled off, for lack of a better phrase, about the criteria for the evaluation of the BLM waivers. I don't know that I have that ready access in my materials. Is that, where would I find that, Mr. Nguyen?
Mr. Nguyen?
That is, that's the 2019 record of decision for the ARMPA.
Okay.
Thank you.
Thank you.
And I can, if the commission wants, I can send that exact page number, that exact citation or whatever if you want. It's a big document, but.
Why don't you call and paste that page number and get it over to Ms. Larson, Mr. Nguyen?
I will do that.
Thanks.
It's table G1.
All right. Thank you. I'm seeing no further questions. We will zoom away the panel.
Thank you, Mr. Chair.
Thank you. Probably appropriate for our morning break. It is 11:01. Let's return at 11:15, and then we will hear from staff. Welcome back, folks. It is 11:15. We will get started with the remaining portion of the morning hearing, and that will be a presentation by COGCC and likely CPW staff. Director Murphy, good to see you.
Thank you, Chair. Thank you, Commissioners, and thank you to all the Coloradans tuned in today. I'm going to share my screen, and bear with us as we'll have to kind of jump between presentations this morning. Hopefully folks can see my slides. Great.
We can.
Thank you. And as you noted, Chair, we are here to give staff's closing presentation on the 1200 series and the protection of wildlife resources in particular. You'll be hearing from both me and Mr. Duranlo on kind of some of the process-oriented issues that we've heard raised during this rulemaking, and also from Mr. Ackerman and Mr. Holst about some of the more substantive wildlife requirements. I think, as I think about the presentation, Mr. Duranlo and Mr. Holst will be talking about the practice of how these rules work, and Mr. Ackerman and I will be focused a little bit more on the theory or the framework leading us into how we structured the 1200 series rules. I would also note we have a late breaking edition of Mr. Taylor Elm will join us at the conclusion to talk a little bit about grouse. He's new to the hearing presentation realm, but he's certainly not new to these issues or to wildlife generally, and the interrelationship with locating and managing oil and gas impacts. So with that, I would jump to my next slide, which to me is to recap again the mitigation hierarchy that the proposed 1200 series rules include, and illustrate that we have tailored the rules to reflect the mitigation hierarchy, which is those impacts that should be minimized and mitigated versus those impacts that require avoidance to protect wildlife resources. These represent the tools that CPW recommends for wildlife resources. So jumping into it, if we think about rules 1201A and 1202A, we're thinking about statewide protections. It applies to 100% of the state and allows for a consideration of wildlife that are not more specifically addressed in other rules. So this is again, starting with the big picture lens and probably the least specific provisions. Turning then to 1201B and 1202B, we have CPW has identified its high priority habitats and included specific recommendations for how to protect wildlife resources within those high priority habitats. And again, this is a subset of Colorado. Now within high priority habitats, there are 3 subcategories that include more enhanced protections as we believe are warranted based on the wildlife recommendations from our partners at CPW. First, we think about the density habitats in 1202D, and this occupies a fair number of the high priority habitats, but allows for us to protect relatively intact habitats from fragmentation. A second subcategory within the high priority habitats that receive enhanced protection under staff's proposed rules are the non-aquatic habitats. And for these, there is a no surface occupancy requirement proposed to presumptively avoid development in these most sensitive of habitats. The third subcategory within high priority habitats that have a separate or special treatment are the 1202 C1 Aquatic Habitats. We've heard a lot of discussion about these. And in our mind, the no surface occupancy restriction continues to be important in these areas, but there are some appropriate exceptions. One would be for access road construction and flow line and utility corridor clearing and installation. A second would be that CPW and the director, can waive the no surface occupancy for intermittent and ephemeral streams associated with the aquatic native species and sport fish management waters. Again, in my estimation, science shapes policy. It doesn't dictate outcomes. And to me, the best policy decisions are informed by the breadth of data and reflect the appropriate balance of those outcomes. In my mind, we have proposed just that. Broad statewide protections that allow a lot of flexibility and unique considerations. And then as we drill down to those things that are most important and most important to avoid in particular, they cover a narrow band of acreage and reflect, again, our experts at CPW's recommendations. I do want to flag my thanks to Brandon Moret, Bob Sacco with CPW, and Mr. Duranlo for helping me with this slide. You've seen enough of my presentations to know that animations and graphics are not really my gift, but we wanted to be able to provide to you both a both the words on the page of how we think this works and a visual to illustrate how we think these rules work and are consistent with the 181's creation of a mitigation hierarchy. So next slide. With this framework in mind, I'd like to talk a bit about the theory behind the implementation. To me, 1202C is critically important because it creates transparency, certainty, clarity, and consistency for planning. The rules implement CPW's recommendations presumptively in that the CPW recommendation for 1202C lands is that these habitats do not see development. However, this is not without rigidity that would ignore the on-the-ground information or would preclude ground truthing. To suggest otherwise, to me, ignores the clear language in 309E3C, which applies to all 1202 subparts, including 1202C. And you can see that language in the text box that I've snipped from the staff's October draft rules. In that, if the operator demonstrates and CPW agrees that the habitat or species triggering consultation are no longer present, consultation is not required. Or if the operator and CPW agree that the proposed oil and gas location is within an area either primarily or completely developed for residential, agricultural, commercial, or industrial use. So I think that there is on the ground truthing available. And so to me, the question on the table is really whether 1202C should be subject to a waiver or a variance. And the context for staff's framework is to integrate CPW's recommendations, which are to avoid the 1202C habitats. And an important component is that variances do not require a separate hearing. So to me, the waiver process implies that there is an intent to negotiate conditions of approvals within no surface occupancy areas, which places some burden on CPW to prove case by case, day in, day out, why development within the NSOs is not appropriate. In contrast, a variance process reinforces the intent of CPW's recommendations that these habitats should be avoided and places a burden upon an operator to prove why siting within them is appropriate. Folks suggesting that CPW needs more or different tools within 1202C ignores the tool that CPW has in fact recommended in 1202C, which is avoidance. So turning now more to the philosophy, right? Whether a variance or exception for wildlife is included or not, the question of whether to improve or deny a proposed oil and gas development will come to this commission for a decision during a hearing. This body will be evaluating that proposal, and each location will come to you with a myriad of considerations, not just wildlife. However, the rules before you are focused on the issue of protecting wildlife resources and designed to ensure that you receive a clear, unfiltered recommendation from our partners at CPW about how to protect wildlife as it relates to a particular location. How you as commissioners ultimately weigh that piece of information with other considerations about each unique location will be the work of this commission. With that framework in mind, it is my recommendation that we structure the 1200 series to clearly, transparently, and consistently reflect CPW's recommendations as informed by its review of the relevant literature and data, and 1202 in particular provides just this clarity, consistency, and certainty. In addition, these same concerns about conflict and input from a federal or local government apply to any other number of COGCC regulatory requirements. Two that come to mind would be secondary containment or remediation requirements. In these situations, we do not have a special exception process and instead let all of those factors come to you commissioners for a final decision. I suggest that this is the appropriate process for wildlife as well. Again, 1202C represents CPW's recommendation that to protect wildlife resources in these habitats, development should be avoided. Turning now to a bit about the federal relationship. The federal government has an important perspective and expertise, and it also uses a different lens and decision-making process than either COGCC or CPW when reviewing a proposal for oil and gas development. BLM in particular is a multiple use agency that considers wildlife protection as one of many elements that include grazing, recreation, energy development, mining, etc., and has field offices throughout the state and nation to make individual decisions as compared to our commission and CPW. In particular, our commission has you 5 commissioners as a decision-making body that applies statewide. And in contrast, to the multiple use and multiple field offices, COGCC and CPW have more focused missions on a singular issue, COGCC with regulating oil and gas and CPW with protecting wildlife resources. And so to me, it's important to consider everybody's respective spheres of expertise and purposes when we're thinking about how to integrate their views on a particular issue. There is really important information to be drawn from the federal process into COGCC's process for consideration. And we spent a lot of time working through that and reflecting that federal decision-making process into the rules and the state decision-making process in the 300 series. Part of that is through coordination and part of that is through consideration. So I want to point out that our permitting process not only allows specifically encourages collaboration and consultation between the federal government and us. And to reiterate, we built this process in the 300 series because there are any number of issues in addition to wildlife that will need to be specifically evaluated again. I could go back to the point that I made earlier, but I won't. Thus, creating a separate exemption process for wildlife as it relates to the federal government to me does not seem appropriate. Second, we have specifically created rules that require consideration and integration into our state process, the federal decision-making documents, and in particular, conditions of approval. We think that this provides you commissioners with the right information from the right people at the right time when you are ultimately weighing what decision to make about a particular permit. We have heard quite a bit of discussion about the MOU. I think it does create a process through which we can continue to integrate the respective processes between COGCC and BLM. We continue to look forward to working under that MOU and, if appropriate, revisit it to bring it into today's standards. We've also heard some discussion about federal planning documents, and I think that these are very appropriate to consider in the context of the date and the geography in which they were finalized. And we also recognize that field offices can have different approaches across different parts of Colorado. In contrast, through the 1200 series, we are asking you to adopt rules that apply consistently across the state of Colorado, and that consistency is important to implementing CPW's expertise and COGCC's regulatory authority across the state. And with that, I would turn it over to Caitlin or Ms. Stafford. So thanks for your patience as I figure out how to do that.
Can you hear me now? Great. Thank you, Director Murphy, and good morning, Commissioners. This morning, I will address two legal issues that deserve some more attention following the party presentations at the end of last week. Those are the high priority habitat map updates and the definition of minimize adverse impacts, as that term relates to the mitigation hierarchy. Turning to the first issue, the high priority habitat maps and staff's recommendation on how to treat map updates. As you'll recall, staff has proposed that the maps be adopted as a COGCC rule. There are important advantages to this approach. First, adopting these maps as a rule creates regulatory certainty as the maps will be enforced statewide. These maps will then be ground truth through the consultation process with CPW. Another advantage involves the recent transition to a full-time commission. Where the commission was unable to address more regular map rulemaking in the past, there will now be more capacity to do this type of periodic rulemaking. Understanding this, staff recommends that the commission direct staff to notice a map rulemaking every January to cover the high priority habitat maps, as well as other map layers in the rules, like the Census Bureau data that will need to be updated for the disproportionately impacted communities definition. I would also like to address the idea that the high priority habitat maps could be viewed as interpretive and therefore do not require formal rulemaking by the commission. As I've mentioned, there are important legal and policy advantages to making the maps a commission rule subject to rulemaking, and this is staff's preferred approach. But even if the maps were viewed as an interpretive rule, there is one key point to remember about the maps. These are CPW's high priority habitat maps, and the APA's incorporation by reference provision applies here and discusses the requirements that apply when an agency incorporates the codes, standards, guidelines, or rules of another agency. Basically, the APA is trying to say that if you get information from an outside source and put it in a rule, you can't change it whenever the outside source makes an update, because that would effectively allow the outside source to change the agency's rules without conducting a rulemaking. So even if CPW's maps are interpretive, They are in any event a guideline or a standard as envisioned by the APA and should be subjected to the COGCC rulemaking process. Next, I would like to turn to minimize adverse impacts and how this term relates to the mitigation hierarchy clarified by Senate Bill 19-181. I hope to provide some clarity around this topic, and I'm happy to address this further if there are additional questions. During party presentations, a stakeholder made an argument that was premised on the idea that staff is attempting to redefine a statutorily defined term. SB 19-181 defines the term minimize adverse impacts at section 34-60-103, and it reads as follows. Minimize adverse impacts means, to the extent necessary and reasonable to protect public health, safety, and welfare, the environment and wildlife resources, to A, avoid adverse impacts from oil and gas operations, and B, minimize and mitigate the extent and severity of those impacts that cannot be avoided. The term is defined in section 103, sets forth the mitigation hierarchy by directing the Commission to first avoid impacts, then seek to minimize unavoidable impacts, and finally to mitigate those impacts. However, the statutorily defined term incorporates one of the same words it is attempting to define, minimize. Staff's definition of minimize adverse impacts as proposed as part of the wildlife rules is not intended to redefine the statutory term minimize adverse impacts found in section 103. Instead, staff's proposed definition is intended to define minimize adverse impacts as it is understood within the mitigation hierarchy of the statutorily defined term. That is, staff is attempting to define the undefined terms within the statutory definition. Ultimately, in order to better clarify staff's intent here, staff is open to adding language to the SBP specific to this issue at the Commission's direction. With that, I will turn it over to Mr. Duranlo.
Thank you, Ms. Stafford, and I will attempt to share my screen. And I will make the assumption that I can be heard. I'm going to talk today briefly more on the process and highlight some of the changes that staff has proposed to just kind of reiterate some points that we've made. Apologies in advance for any repetition, but we do think that there are some points that we're making today that deserve repetition. Overall, the framework of the 309E consultation process is the same as it's been since the House Bill 07-1298 rules were adopted. COGCC, in partnership with CPW, have identified habitats and species that warrant protection. We've provided mechanisms for avoidance, minimization, and mitigation of impacts to those habitats and species. And we've provided for consultation with our wildlife consultant, and that's Colorado Parks and Wildlife. A concern that we've heard a lot about is the lack of an exception process for the proposed no surface occupancy areas, as opposed to the prior process with restricted surface occupancy areas. And as Director Murphy stated, and this will be repeated a few more times today, this is not the right approach. If an operator wants to be in these most sensitive areas, the burden is squarely upon them to demonstrate that they can do so without adverse impact. This slide shows the difference between the current lands affected by the sensitive wildlife habitat and restricted surface occupancy areas of the HB 07-1298 rules, and in the upper left, and compared to the high priority habitat lands at the statewide scale, and also for an area in the Piceance Basin. You'll notice that the change in acreage affected by consultation is in that area in the Piceance Basin is fairly comparable, but the change in acreage from the RSO to NSO, as shown in the lower left, is definitely more significant, with the increased buffer distances for greater sage grouse and the addition of the aquatic habitats. I think it's important to remind us all that the largest change in acreage is for the aquatic habitats. But those are habitats for which the rules also, as Director Murphy mentioned, provide the most flexibility on implementation, including for the crossings of the habitats with access roads and pipelines, and for the CPW waiver provision for intermittent and ephemeral streams, which make up about 1/3 of the sport fish habitat and nearly half of the native aquatic species habitat. So turning to the consultation process or the application process itself, the draft rules in no way restrict, and they actually encourage early consultation with CPW in all cases. And this includes discussions about the 1202C NSO habitats. Consultation Rule 309E3C provides off-ramps on a case-by-case basis for exactly the reasons set forth by some of our stakeholders, which are if the habitat and the species are not present, then CPW can grant a waiver to the consultation provision. And that, you know, so if the species and habitat are not there, there's no variance necessary. That is an approved, a waivable situation. Industry and Western regional local governments raised two interrelated issues related to 1202C. They have to do with the timing and the process available for an operator to seek to go through the process for 1202C habitats. So with respect to the timing, if the operator engages in a robust pre-application consultation, they will know right away whether or not CPW will support the request. They wouldn't go through the entire process to the end and suddenly be surprised that CPW doesn't support their variance request. So a variance would be considered by the commission as part of the entire package for the permit, and the operator would know whether they've got CPW support. The operator would then know that they've got whether or not they've got the director's support for their variance request. And the permit package, by the time it reaches the commission's decision point, would include all the relevant information from the relevant local government, from the federal land management agencies, from CPW, and from COGCC staff analysis. So with respect to the process, the strong push for waivers disregards that CPW has made their clear recommendation. They've already given us their professional judgment that these habitats should be avoided. And that's the ultimate purpose of a no surface occupancy area. Siting within that important habitat should require an affirmative demonstration that no harm will be done, and that's appropriately achieved through a variance process. So one overarching point on the interaction of federal and local governments throughout this process is COGCC has one partner to consult with on wildlife, and that's CPW. We certainly take in information from other partners, local governments, private citizens, interested groups with various expertise, but CPW provides the recommendation to implement the statutory direction of how to protect and minimize impacts to wildlife resources. And this was established in House Bill 07-1298 and solidified in Senate Bill 19-181. For local governments, there's certainly interaction with our process. The interests of local governments will be engaged by CPW and COGCC in the alternative location analysis process. And local government siting and evaluation processes can inform or be informed by the COGCC process, depending on how they've determined to implement the authority established by SB 19-181 based on the directive from the General Assembly. Many local governments already solicit input on wildlife from CPW on their land use decisions. CPW has the direct primary expertise in addressing wildlife protection, including compensatory mitigation, And in contrast, local governments have direct primary experience in land use. And we recognize that many local governments have invested significant time and resources into wildlife management in their jurisdiction. For example, Gunnison County. But notwithstanding that, COGCC still relies on our primary consultant for wildlife, and that's CPW. And last, I'm going to just kind of walk through the process and steps to highlight a few points. So the operator starts their planning and location selection process, and right away they can start reviewing for the alternative location analysis triggers. Those include the setbacks to building units, they include a high priority habitat, disproportionately impacted community, and so many other things that play into where the operator chooses to site their location. Once they've selected the site that works best, then they can engage the land managers, either the federal government through NEPA processes, through the local land use requirements, and then at that time also to begin their consultations and their pre-application consultations with CPW. If in that process they demonstrate that the habitat and species are no longer there, then CPW can waive the formal consultation process per 309E3C. And that applies to the 1202C NSO species, and it applies to the 1202D density determination species, and it applies to the non-listed species that require consultation. Following that, or alternative to that, the operator can still make a demonstration that siting within that high priority habitat can be done without adverse impact. And so for the aquatic species, we've provided that waiver. For the consultation, given a showing of they can operate in there without impact. And then for the for the density determination species, again, if they can show that they can operate in the area without significant impact, then CPW can waive consultation. For the 1202C, for the non-aquatic species, that's when the operator can request a variance, and they can submit that request with their application. CPW may very well concur with that, with that variance request. As stated, maybe it's adding wells to an existing pad, or CPW may look at that same situation and say, adding wells to that existing pad isn't the right approach. It should be located on a new pad outside of the habitat. Following that, the operator submits their application, their oil and gas development plan. COGCC staff conducts their review processes, which includes the consultation, unless it's been waived. COGCC staff, the director, will make her recommendation to the commission based on the findings of the entirety of the application package. And then again, as stated before, all of that information goes forward to the commission for a decision. Whether or not there's a variance request in that application, those steps all follow, and ultimately an informed decision can be made by the commission. And so now I will pass this baton over to Mr. Ackerman, if I can figure out how to stop sharing my screen.
Thank you, Mr. Duranlo, and thank you, Mr. Chairman and members of the Commission. Again, Brett Ackerman, Southeast Regional Manager for Colorado Parks and Wildlife, and we are grateful to be here in these Commission hearings. We have been listening and appreciate all of the important questions that have been asked by all sides on the issue. I wanted to talk just a little bit about, add some clarification to a couple of things that have already been stated, but also talk a little bit more about the development of wildlife management policy in general. Then I'll touch a little bit more on the 1202C avoidance issue, and then talk also about our coordination with the federal government. And I think one of the things that's most important to think about as we're pondering our approach here is to think about the value and applicability of empirical evidence. Empirical evidence derived from research studies has been discussed considerably during this meeting. And while empirical evidence is certainly very important, it's a misconception to think that empirical evidence dictates all management actions and that no action can or may be taken unless there exists directly correlated empirical data that dictates clear management options for all scenarios imaginable. If this were the case, really no expertise or professional judgment would be necessary on any part, just a dichotomous key and someone to read it. In truth, what happens is the scientific method takes place. And that's that we make observations on the ground, those raise questions, we form hypotheses around those questions, and then we test our predictions associated with those hypotheses. And then we iterate the results once the data comes in. Or in other words, we use those results to make new hypotheses or predictions. In this way, biological science is always building upon itself. And while there may be some direct questions answered, it really adds more to the body of understanding so that professional judgment may be made. So these studies rarely result in an A plus B equals C formulaic management approach. Instead, the body of literature informs managers by providing data points in order to make professional management decisions. Management then draws on that body of literature, but also experience, technical expertise, site conditions, and a host of other parameters that managers apply using professional judgment and common sense. Consequently, studies do not necessarily need to explicitly recommend a buffer for any given species or any other best management practice in order for managers to legitimately assimilate that information and use the best available science in conjunction with professional judgment to incorporate a study's findings into CPW's, or in this case, COGCC's decision-making matrix. As a matter of fact, we've seen a demonstration of this principle in action during these very hearings with regard to potentially extrapolating the greater sage-grouse buffer to apply to Gunnison sage-grouse based on our best collective judgment as an entity. Elements of the studies are generally assimilated and applied to a variety of situations, and very little existing literature will be in 100% alignment with a particular proposed management scenario, as animals and landscapes and conditions are dynamic. So this is where professional expertise and judgment comes in. And the way that this professional expertise and judgment has been exercised in part in these regulations is in identifying and setting graduated standards of habitat protection based on habitat sensitivity and habitat importance. And that's a prudent approach and a standard operating procedure within wildlife management. So how does that apply, that philosophy apply then to the 1202C habitats? You know, in my opening statement, I mentioned that in these hearings, no one would advocate for getting rid of wildlife or getting rid of people, and certainly that's proven to be the case, but the devil is in the details. And so the philosophical approach to these draft regulations, as approached by CPW staff and COGCC staff in their drafting, has been what is necessary and reasonable to truly conserve wildlife in perpetuity while developing oil and gas resources. So as Director Murphy outlined, these draft rules are designed to permit flexibility where general best management practices, conditions of approval, or other strategies can allow wildlife to essentially work around where work around development. The rules then ramp up protections on various levels as it becomes more difficult for wildlife to work around such development. And ultimately, recommending avoidance as a rule in, again, 3% of the state's terrestrial habitats and wildlife mapped riparian areas equaling roughly 9% of the state's geography. So while avoidance is almost always a better strategy for all practices in all places from wildlife's perspective, a statewide strategy of avoidance isn't reasonable, it's not necessary, or it's not even prudent if societal will is for people to live in places inhabited by wildlife. But what is prudent is to protect with increased protections the most important habitats. So keep in mind that as we've been having these discussions about waivers versus variances, this isn't a general practice, we're talking about these very limited habitats. And 1202C habitats represent those places in the state that, in CPW's professional opinion, need the most protection. These habitats support the most important life cycle functions of the species identified in the rule, And if societal will is to ensure the well-being of these species in perpetuity, avoiding these habitats as a general rule is the most effective strategy. Nonetheless, and contrary to some of the testimony that we've heard, these regulations do allow for site-by-site analysis and encourage site-by-site analysis of even these most sensitive habitats, and even exceptions where warranted. So considering the importance of these habitats, their relatively limited geography, and the interest of the public in protecting these areas, a commission variance via a public hearing is the strongest process to discuss and approve or deny exceptions to development in these critical habitats. A general principle of avoidance in these areas, employing a process in which proponents proactively demonstrate, in a hearing open to the public, something the public has clearly requested, how they can operate in these habitats with no impact to wildlife is important. Rather than a true NSO, the waiver process implies the presumption of potential drilling activity in the absence of empirical evidence specifically demonstrating negative impacts. In these narrow habitats, a variance, which really is essentially a commission-issued waiver, is the most effective and reasonable employment of the precautionary principle that you've heard about during these hearings, and it's consistent with the intent of Senate Bill 181. With that, I wanted to talk just a little bit more about our work with the federal government. We do indeed work closely with federal land managers, and CPW does this by participating in RMPs, in federal land use planning efforts, and in specific land use actions and a number of other federal planning efforts. As I mentioned in my opening comments, we have local wildlife specialists geographically distributed throughout the state and assigned to every inch of the state. We call them district wildlife managers. There's 130 of them out there on the ground. And they generally work with local officials, with federal officials on land use issues, and they employ deeper specialties within CPW as necessary, some of which have joined us on this call today. I also wanted to note that there are many other entities throughout the state, be they federal or local, that may or may not employ local wildlife specialists, and they often also look to us for local and state wildlife recommendations. We consistently make those recommendations, and we consistently make the same recommendations to all, regardless of land ownership. Federal documents referenced in the Statement of Basis and Purpose, as mentioned, had a range in dates from 1993 to 2020. And they are, like many rulemaking and other processes, frozen in time. Each document reflecting the BMPs incorporated at that time. They reflect the philosophies of different field offices. They were developed under a multiple use philosophy under which a single entity is the regulator, landowner, and the recipient of royalties. CPW's recommendations are specific to the conservation of wildlife, incorporating BMPs, management principles, and habitat conditions continually as they continue to evolve. The federal plans cited do provide important data points, as pointed out by Mr. Dronlow. They demonstrate that the concepts being proposed in these regulations are not novel and they're not unprecedented, but they've been employed in various forms for many years, even in multiple use areas. CPW believes statewide consistency is important. This was the impetus of the HPH process, ensuring that we make the same recommendations, species by species, landowner by landowner, type of use, irregardless, across the state. Employing this statewide methodology does provide landscape scale management tools across the state under one set of standards designed to conserve the state's wildlife as a whole, a geographic analysis plan, if you will. And finally, I just wanted to touch really quick on species that have been mentioned that are listed under the Federal Endangered Species Act as either threatened or endangered. And specifically, we've heard about the black-footed ferret and Preble's meadow jumping mouse. I wanted to clarify that under these existing rules, under previous rules, under the existing rules, CPW had to always trigger a consult on any species that was listed under the ESA. These new rules, these proposed rules, require operators to consult with CPW within mapped critical habitat of any federally listed species. You can find that in Regulation 309E2B as in boy. And then outside of that, CPW can request consultation if presence is known outside of a mapped critical habitat, which is sometimes the case. For example, black-footed ferret location release sites are not published. They're not public knowledge or publicly put out there under agreement with the Fish and Wildlife Service, but CPW is acutely aware of them and can request a consult under the draft regulations. The state does have a great interest in keeping species off of the endangered species list and in working to conserve and delist those that are listed. This is paramount under our mission to protect wildlife. It protects biodiversity, and it also keeps wildlife within the purview of state wildlife managers. With that, Mr. Chair, I believe our final presenter is Mr. John Holtz, who will put a finer point on some of the issues that we've been discussing.
Thank you, Mr. Ackerman.
I need to share a screen here, so
we'll need Mr. Ackerman to stop sharing.
Thank you, Mr. Chair. I have lost my controls here, so I'm trying to desperately find them.
All right, Mr. Holtz, I think you now have an ability to share.
thumbs up if you can see my screen. Great. Thank you, Mr. Chairman, Commissioners. It's a pleasure to be back. Thanks for inviting me back. I'd like to just briefly hit on 4 topics that were raised in testimony. The first, again, is high priority habitat. Hopefully I can give you some final points of clarification on high priority habitat, although I suspect they won't be final. We'll probably hit it again. I'd also like to chat a little bit more about greater and Gunnison sage-grouse lake buffers. I will not go into them in great detail, just a couple of points. I will defer at the end of my presentation to Mr. Taylor Elm, who can actually give some great insight into the greater sage-grouse lake buffers that appear in the federal plans. I'd also like to discuss the pros and cons of using location density as we proposed in 1202D versus what we heard in some testimony related to a disturbance cap. And then lastly, I'll talk about the assumptions behind how we did our calculations for compensatory mitigation. Huh. There's all kinds of weird things going on here. Have to excuse me for a minute, Commissioners. I'm having some technical difficulties.
Not a problem.
There we go. High priority habitat points of clarification. There seemed to be some interest in, kind of looking behind how we actually come up with our high priority habitats. I went over that previously in our opening statement. But just to make the point, it really is an internal process that's intended to provide CPW staff with consistent maps and land use recommendations that we can put out there to various regulatory entities and land use entities statewide. So I did talk a little bit about how we update the maps. Most of our maps are updated on a regional 4-year rotating cycle. We do have some of the site-specific maps, some of the more sensitive localities like greater sage-grouse lakes and raptor nests that are updated every year. But beyond the maps, really just as important or maybe more important are the land use recommendations or our best management kind of recommendations that go along with the maps. And to update those, our staff look at the research that they complete internally, as well as other peer-reviewed research around the country to come up with those recommendations. And then those recommendations really, and that process we go through, the intent is that we come up with really our collective CPW position on what is the best way to manage those habitats statewide. And we do that really without input from other entities on purpose, because we're trying to formulate our position to take that into public processes like this one and other land use processes statewide. And so that's what that's all about. Some of the stakeholders brought up that we did in fact send then COGCC Director Robbins a letter that included an HBH table on January 6th of 2020. And some of the species that were in that letter do not appear to be on the table that we're currently using as a high priority habitat table. So the question really is, where what happened to those species? You know, where did they go? Well, really, we were actually, for the most part, trying to simplify that table because there was duplicative habitats on the table. So I've got on the screen here our native fish and other native aquatic species conservation waters. Really, we didn't eliminate any of the aquatic species from that January 6th table. They were all rolled up into either this native species category or the sport fish management category. So none of the aquatic species were eliminated from that January 6th table. The ones that are highlighted here is just the ones that actually come up right out of our swap. So that's how we did that. But we were intending to actually simplify things and ended up raising a lot of questions. Now, there were some terrestrial species that were actually dropped from that table that appeared on January 6th, just a handful. Brett mentioned one, or Mr. Ackerman mentioned one. That was the black-footed ferret. And that is because, again, we don't release the actual reintroduction sites to the public. We do have those mapped only at the county level, which isn't really useful for triggering consultations. You know, similarly, another one that I mentioned in my talk the other day is swift fox. Really what we're concerned about is active den sites. Our staff may know where those are. We don't have a good map layer for those. What we do have is overall range for swift fox, which again covers a lot of eastern Colorado and really isn't informative for triggering a consultation. As Mr. Ackerman mentioned, we can request a consultation under 309E2D in the proposed draft, and that is what we would intend to do for those types of species where we do know where there are some specific localities or our local staff may, but we don't have a comprehensive map statewide that we can use that is informative to trigger consultations. Similarly, you know, I would just point out that in the odd likelihood that we would have a migration pinch point or stopover area that we were not consulting on because it wasn't within a 1202D mapped habitat, if local staff knew of one of those that was not mapped, we could bring that up in this consultation process as well. And even beyond that, you know, if there was a well proposed I think it was Ed Arnett from TRCP had mentioned it, you know, what if there's a well going in next to a wildlife crossing structure that's been constructed? You know, we could, if we didn't feel like that location could be mitigated, even though it's within that 1202D category, if mitigation can't solve the problem, then we could recommend well denial if the well can't be moved. So that is an option that's still on the table. And then lastly, Mr. Ackerman already mentioned this for the Rule 309E2B, those federally designated critical habitats do automatically trigger a consult under this proposed draft. So greater and Gunnison sage-grouse select buffers, we did include those in 1202C, both because of the sensitivity demonstrated in the literature of those grouse, lecking grouse to disturbance, and because of inadequate mitigation options. I think we heard some testimony and there's some inquiry into whether or not those habitats could be mitigated. I know there was an example given of some attempts to actually move display grounds that were not successful. And I was reminded after that discussion by our research staff that really grouse select those leg sites really because it is the highest quality nesting habitat, and they're really telling us where that habitat is on the landscape, and we do not know how to mitigate that nesting habitat feature or the highest quality nesting habitat in order to get grouse to display in a particular area. That is an unproven science. So we do feel that 1202C is the most appropriate spot for that, and we do not feel that like we have really good options to mitigate for impacts to sage-grouse legs. We did hear some testimony on Gunnison sage-grouse and the fact that our recommendation was a 0.6 mile buffer versus a 1 mile buffer for greater sage-grouse. There is a significant body of literature that supports that 1 mile buffer for greater sage-grouse, and it could logically be extrapolated to Gunnison grouse. That was not our staff proposal because given the absence of oil and gas specific literature, we did elect to go with consistency with the community, Gunnison County, that has the majority of grouse in that county, and what was in their existing landscape prioritization tool that they use for siting developments within the county. But we would not be opposed to a 1 mile buffer for Gunnison sage grouse. It would certainly be more protective of grouse. We just did not put that forward in our staff proposal. So the back to the 1202D, the oil and gas location density versus the disturbance cap. We did hear a fair amount of testimony on using a disturbance cap for those habitats. And, we do recognize that, if we could control all land uses and manage those with a disturbance cap, that would in fact probably be the best thing for those habitats and for wildlife. There are some real difficulties with that, though. We did talk about that quite a bit internally. We're not like the BLM where we manage all of our lands. We're not like a county. So really, logistically, managing a disturbance cap when really we're talking about the regulation of one industry with these regulations becomes pretty difficult to handle. In addition, we have the ability with oil and gas locations to get real-time information. So, we can pull off of COGICC's webpage, proposed wells, existing wells, plugged and abandoned wells, whatever we want, literally real time. Whereas with a disturbance cap, somebody's got to go out there and digitize the disturbance, literally, on a weekly or monthly basis, just to keep track, especially in some of these communities that are receiving a lot of development. So that becomes problematic. And then lastly, as CPW and our biologists, we really do want to look at the character of the impacts from all of those other types of land use and really how they're impacting wildlife as compared to oil and gas development before we try and assess what the likelihood of indirect impacts are from additional oil and gas development on wildlife in that area. We also heard about, using that sort of 1 mile, one location per mile as a metric for looking at density and impacts to those 1202D habitats. And there was suggestion to use our data analysis units, or DAUs as we call them, that we have for various big game species across the state. So in this map here, I've highlighted for you D7, which is where the red circle is. It's this whole pink area. And that is the area where I showed you the spaghetti migration map last week. What I have highlighted in red here is really sort of the side of that DAU that is the wintering area. And I guess one of the difficulties we have with using that scale or a DAU kind of boundary to manage density, whether you do it with location density or you do it with disturbance cap, is that all of the, literally, if we did it that way, all of the development could be located within the most sensitive areas within the DAU. And that really doesn't get to our goal, which is to keep the entire landscape permeable to allow wildlife to move through the landscape as they normally would. And so we did not take that that scale as our approach. In addition to that, using the DAU scale, so that, this, what I've shown here is our deer DAUs on the western slope. But the outline of those polygons are different for our elk DAUs, and they're different for our pronghorn DAUs. So essentially, if we were to use a DAU as the boundary for managing density or disturbance cap, we would need to pick which species we're going to do that for, because we would essentially have competing species or competing DAU boundaries trying to manage the density. So that would not work very well for us. So we have talked about this with various stakeholders, and we've talked about this with our COGCC counterparts. We are going to have to issue some joint guidance on the GIS methodology for how to calculate oil and gas densities per Rule 1202D. We have toyed around with different techniques. We haven't settled on anything, but the GIS methodology that we use will likely use some sort of neighborhood analysis that looks at the surrounding miles square, if you will, to calculate the density within a particular square mile. once we figure out the methodology for doing that, that methodology could actually be incorporated into COGIS on COGCC's online mapper and be just pulled down as another layer. One of our staff actually came up with this graphic. It's not necessarily how we would choose to calculate that location density, but it certainly gives you an example. Shown in green here would be the 0 to 1 location per section, where we're not so concerned about indirect impacts at this point. Shown in orange is the 1 to 5 location per section, where per the proposed draft rules, we would want to talk about what we can do to offset additional the indirect impacts from additional development. And then the red area here, which is over 5 pads per section, is where we would essentially say, you know, we're not as concerned about indirect impacts anymore because we think they're pretty widespread in that area. And so this slide just gives you a comparison of, you know, based on our average well location size in Colorado, which we said is a little under 6 acres. Granted, it does vary, but that is the average. You know, that one oil and gas location per section metric really amounts to less than 1% disturbance if you're looking at it in terms of overall disturbance cap just from oil and gas. 3 oil and gas locations per section would be still just under that 3% disturbance cap that was mentioned. So, you know, based on our average location size in Colorado, the 1 oil and gas location per section that we've put forth in the rules appears to be more conservative. But given all those other factors I just talked about, it also does provide some flexibility to allow for other types of land use that we do not regulate under this rule package. We also heard some testimony related to specifically, you know, our big game habitat maps maybe being a little overly broad. And we don't disagree that they should be 1202D. We do think that that's the appropriate place for our big game habitats. But I will just say that, and this map kind of illustrates it, Craig is right here. And there were some statements made about, you know, parking lots in Craig are mapped as CPW, in this case, severe winter range. And there is a reason for that. I mean, we don't specifically excise you know, parking lots and things that are no longer habitat features within some of these developed areas. But as you can see from this map, this just shows some radio collar locations. In addition to these radio collars, you know, our folks fly these habitats, especially for big game in the wintertime every year, and actually have a really good idea of where big game are in the wintertime. And so those are some of our highest resolution maps in a way. And so if the area around Craig is mapped as severe winter range, there's a pretty good likelihood that big game are using that area right around Craig. And with some of these western communities, particularly that are adjacent to public lands that have closures on them in the wintertime, some of those areas next to some of these occupied cities and towns are actually quite important to big game. On to our compensatory mitigation fee assumptions. So again, and I did mention this last week in our opening statements, but we did use statewide averages when we came up with the size of our average oil and gas location statewide, our CPW costs to improve habitat to offset that short-term habitat loss. We used our average sort of statewide looking at habitat improvement projects. And we used the average cost of conservation easements based on the easement appraisal value statewide. We did eliminate a few outliers in like Aspen, Pitkin County. Another assumption that we used is that, you know, we assumed that short-term habitat loss can be mitigated through habitat improvement projects at our CPW cost to improve habitat elsewhere without having any sort of land protection associated with that habitat improvement. And really the intent of these calculations and the assumptions behind these calculations were to approximate what our cost would be as CPW to replace the habitat function of the habitat that's impacted by the development of that location. And with that, I will quit sharing my screen and I will turn this back over to Mr. Elm. to talk
Thank
a
you,
little bit
Mr.
about
Holtz.
sage grouse. Just have to figure out how I do that. There we go.
There you go.
Thank you, Mr. Holst. Thank you, commissioners. I will try to bring up one item on my screen here. Not sure if you guys can see this quick PowerPoint slide here. Okay.
We can.
And thank you, Director Murphy, for the quick introduction here. Just to reiterate, my name is Taylor Elm. I'm the Energy Liaison for CPW's Northwest region. For background information, I work routinely with BLM staff in our region to implement stipulations and measures in their federal RMPs, specifically the greater sage grouse RMPs that were mentioned earlier. And we wanted to just take a minute real briefly to run through maybe some confusion that was going on there regarding some of the stipulations in these federal plans and maybe how they relate to the draft rules that you have before you regarding greater sage grouse. So on this slide, these three columns, you'll see the 2015 plan that BLM undertook range-wide for sage grouse. This was in response to potential listing decision by U.S. Fish and Wildlife Service for greater sage grouse. In the middle there is a subsequent amendment that was made and approved in 2019. And then obviously the draft 1200 series rule provisions. And as was pointed out, currently BLM is still operating under this 2015 plan due to a court-ordered injunction on the 2019 plan. That is still pending and slightly up in the air. Just to run through really quick, in the 2015 plan, as was stated by Mr. Pedersen, the most significant restriction was that there was no new leasing within 1 mile of greater sage grouse leks. In addition to that, there's NSO stipulation on new leases within priority habitat management areas. And it's important to note that for grouse, their habitat is mapped, or is basically broken into two different categories, this priority habitat management area and then the general habitat management areas. Commissioner Nanjapa pointed out that there is a stipulation in the plans that applies to a 2 mile radius around leks. And Mr. Pedersen was correct, that applies to general habitat management, that is, or habitat management areas that are within that 2 mile buffer. In addition to these NSO stipulations, there is a 3% disturbance cap and a provision for 1 oil and gas facility per square mile within priority habitat management areas. These thresholds really affect future decisions by BLM regarding permitting and leasing decisions if those thresholds are to be tripped. Mr. Pedersen was also correct that when BLM implemented the 2019 plan, really the largest change was dropping that strict prohibition on new leasing within 1 mile of leks and instead changing that to an NSO stipulation that's really the most stringent with regards to allowing opportunities for waivers and exceptions. Really much of the other provisions stayed the same in the 2019 plan for the state of Colorado, as he mentioned. So I think you will see regarding the draft 1200 series rules, we are in fairly close alignment, even though, as I've said before, this is somewhat apples to oranges comparison, given that BLM is a mineral estate owner and leases their minerals, and so these are applied a little bit differently. But you will see we have the same lek buffer with the NSO restriction, the same density recommendation for priority habitat management areas. And then also important to note that general habitat management areas, while not included in 1202C or D, they are an HPH habitat, so they would trigger a CPW consultation which is where we would talk to operators about things like timing limitations and other best management practices and COAs. So hopefully that clarifies some of that interaction between the federal plans and these draft rules and doesn't complicate the matter further. And with that, I can turn it back over to Director Murphy, if that is what she desires.
Thank you, Mr. Elm. And I would just end with one comment that the 1200 series and 1202 in particular tailor the wildlife protection tool to the habitat based on the professional judgment of CPW, including those folks here today, the team of experts that have supported this rulemaking, and the on-the-ground knowledge of the 131 district wildlife managers working throughout the state of Colorado. With that, commissioners, our staff comments are completed. We're happy to take questions, break for lunch, whatever your pleasure is.
Thank you, Director Murphy, and thank you to your staff as well as to CPW staff for the excellent closing and summation of a lot of the good information that we've heard. I, for one, would suggest that maybe it makes sense to break for lunch and let commissioners tally up their thoughts with regard to the closings that we heard and prepare for issue identification and additional clarification and questions to your staff at CPW when we return. I'm seeing Commissioner Njapa nodding up and down. Are the others okay with that approach? Thumbs up all the way around. It is 12:21. Let's return at 1:25, and then we'll start Commissioner questions to staff.